And then, in terms of 53.2, the employer may request such a certificate from the minister, and the certificate is valid, etc. What we now see, Malady, in 53 is, of course, the insertion of 53.6, Malady, which is a new provision, which is one of the amendments that we challenge in this case. And that is now a new provision, Malady, 53.6, that says the minister, and you will the minister now, Malady, in carrying out his or her functions in terms of 53, we are told in peremptory terms by the amendment, may only issue a certificate in terms of subsection 2 if the minister is satisfied that A, the employer has complied with the numerical target set in terms of section 15A that applies to that employer, or B, in respect of any target with which the employer has not complied, the employer has raised a reasonable ground to justify its failure to comply, as contemplated by section 42.4. So, before dealing with the amendments, that is one of the amendments, Malady, the broad submission that we make is that, as is apparent from these provisions, what the Act envisages, the scheme that it put into effect on the statute book, Malady, to ensure that the goals in Section 9 of the Constitution were achieved progressively and in a rational manner while balancing, Malady, carrying out the necessary balancing exercise that section requires. It envisaged, Malady, and required a regime where employers in the first instance were required to give consideration to come up with their equity plans, and then those could be monitored and enforced by the provisions I've referred you to by Director General in the first instance and the Labour Courts in the second, together with the ability to impose fines. Now, that, Malady, we submit was a constitutionally consonant scheme because it set goals, but it did not cross the boundary. And this is a boundary that the Constitution sets, Malady, not us. It didn't cross the boundary into a target which is inflexible, which is so inflexible and rigid, Malady, so as to, if not be a quota, amount to a quota. And we submit it is that line and that distinction which the legislation, the Amendment Act, ignores, and which is why it's unconstitutional, because it crosses over into the terrain of rigidity, Malady, and bluntness, which the Constitution doesn't permit. Now, in order to contextualize that submission, can I take you to the amendments and just identify what they do and what they're saying? And then I'm going to, as you know, there are two arguments, two challenges that we have to the legislation. One the tagging and one the substantive, and I'm going to deal with them in sequence after this introduction. The amendments sought to introduce that have now been introduced are the following. As opposed to section 15, which I've taken you through, now Malady has a 15A, which you find 143 Malady. And it talks about sectoral numerical targets. Now, before I go there, can I just reference, Malady, the following provision in the previous iteration of section 15, as it was before the amendments and still is. So the court will bear in mind, Malady, these provisions I'm going to reference now are still on the statute book, but they now have to coexist with 15A, which is the insertion. 15, Malady, requires, as I've indicated, affirmative action, measures to be taken by employers. 15.2, Malady, indicates what those measures must include, Malady. And it includes, in D, measures to ensure the equitable representation of suitably qualified people from designated groups. So that you see in 15.2D. Now 15.3 says the following, and 15.3 and 15.4 are crucial to a proper understanding of not just the Act, but of the constitutionality of the amendments. 15.3 says, the measures referred to in subsection 2D include preferential treatment and numerical goals, but exclude quotas. So the legislation itself, this Act, in its previous and present iteration, sets itself against quotas. It says employers may set and must set numerical goals, but not quotas. And then formally gives further content to the intention of the legislature in enacting the Act itself, really. Subject to section 42, nothing in this section requires a designated employer to take any decision concerning an employment policy or practice that would, and what follows is crucial to an understanding of this case and our challenge, really, establish an absolute barrier to the prospective or continued employment or advancement of people who are not from designated groups. So nothing done in terms of this Act, lady, may establish an absolute barrier to the prospective or continued employment or advancement of people who are not from designated groups. Now, I'll return to that in my submissions on the merits, but to now go to what the amendment achieves. 15A(1) inserts the following: the Minister may, by notice in the Gazette, identify national economic sectors for the purposes of this Act, having regard to any relevant code contained in the Standard Industrial Classification of all economic activities published by Statistics South Africa. Then sub 2. This is central to the case. This provision, the Minister may, after consulting relevant sectors and with the advice of the Commission, for the purpose of ensuring the equitable representation of suitably qualified people from designated groups at all occupational levels in the workforce, by notice in Gazette, and here are the words of the lady, set numerical targets for any national economic sector identified in terms of subsection 1. And then sub 3, a notice issued in terms of subsection 2 may set different numerical targets for different occupational levels, subsectors or regions within a sector, or on the basis of any other relevant factor. And before giving further attention to that, can I just take the call to the further amendments effected by the Amendment Act. The next relevant one, lady, is to section 20, which deals with equity plans, employment equity plans. I've taken you through that. But what's now inserted is a new 2 capital A, lady, in terms whereof the insertion provides the numerical goals set by an employer in terms of subsection 2 must comply with any sectoral targets in terms of section 15A that applies to that employer. So now, lady, as opposed to being left to the employer on the basis of the careful analysis and calibrated considerations, including consultation with its workforce, trade unions, etc., to achieve its numerical goals, lady, in terms of its policy, equity plan, we are now told by this amendment that the numerical goal that you set in terms of your plan must comply with the Minister's target.
That's the effect of the insertion of 2A. The next
relevant insertion, lady, is 42. And that's 42, I think, in the notice of motion, we incorrectly had in our heads. Possibly our learned friends' papers, everyone refers to 42 sub 1. Yes, 42 brackets 1 brackets small a capital A. It's actually 42, there's no 1 in that, it's 42 brackets small a capital A. And the insertion is In considering whether or not an employed here has complied, the new consideration that's put in is capital A, whether the employer has complied with the sectoral target as set out in terms of section 15A applicable to that employer. So in considering now whether there is assessment, compliance with one of the Minister's numerical targets is an express requirement. And then with regard to 53, I've already taken you to that, lady. In deciding whether or not to provide a certificate, which, as you would have seen, is compulsory to do business with the state, the Minister's prescribed to only issue same if satisfied that the employer has complied with one of the targets. So that's the effect of the amendments. Well, that is the text of the amendments. We say the effect of the amendments, lady, is fundamentally to rearrange in a constitutionally impermissible way the structure that pre-existed in terms of the Employment Equity Act. What was a careful, considered approach to the question of achieving broad representativeness, lady, has now been turned into one where targets are set by the National Minister. What the Act permits the Minister to do is to set such targets, and we know from the examples of the lady, which I'm going to refer to in argument, the initial targets that were set, we know that those were not persistent. But you will recall from our papers that those targets were very specific targets, Melanie. They were broken down across the provinces and across the race groups. So in respect to the designated groups, you'll recall that the targets provided for different figures, Melanie, or targets in respect of Indian, coloured, African persons and for disabled persons. All of them fall within the designated groups. And those targets differed from province to province. And if one failed to hit those targets, Melanie, you would be in violation of the Act, read together with the promulgated targets. Now, it appears, possibly as a result of this litigation, or just upon more consideration, Melanie, the Minister has retreated from and you'll recall we've put those targets up, the initial targets. I think they are DA1 relating to our papers. And not to belabor the point, but and this is fundamental to our argument, so perhaps it's worth making now. If I could just turn, Milady, to the very first page of the targets that were set back, Milady, for comment in May 2023, soon after the promulgation of the publication of the bill, Milady. So these were draft targets issued in terms of 15A, issued for public comment. And can I take you to the very first page? And as you'll know from this document, I'm sorry, Milady? It's case lines. It begins, Milady, at case lines. It's DA1, Milady. It begins at case lines 231, Milady. Sorry. 0231. And then the very first table that you will get, Milady, is at 234. And just to orientate the court, Milady, this is a lengthy document, runs till 269. And what it does, if you look at 234, Milady, headed Agriculture, Forestry and Fishing, you will see there's a block A, top management, B, senior management. If you turn the page, you see C, professionally qualified in the same sector, Agriculture, Forestry and Fishing, and D, skilled. So those are the four categories, Melanie. Skill being the lowest one, and top management being the top one. So there are four skill categories within the sector of agriculture. And if you then go to page 236, you'll see the next sector of the economy is mining and quarrying, and you'll see it has the same 4 sectors, and so it goes. And it covers effectively the entire economy, except for those limited employers who are not.
How do you interpret these targets? Are these the targets that should be met?
Yes, because you'll recall, I've taken you at some length perhaps through the amendments. So what this means, if this, and these are not, I must emphasize, these are not the targets that have now been promulgated. I'll take you to those in a minute. They're among the documents we put up in the supplementary affidavit. But these are the targets, and herein lies the point, and it's essential that the court appreciates this. The DA's challenge to this legislation is not based on the particular targets that the minister has chosen at any particular time. So the minister at least was thinking, in May 2023 of these targets, because that's what were promulgated for public comments. Then the minister, for whatever reason, we can't see into the mind, the lady, thought not a good idea. And then the minister promulgated the new targets, which you find, and the new targets are quite different, because they, for one, so just give me a reference. I'll give you the case line reference here, just to show you how they differ. 08115, the lady, you'll find the new targets. And the new targets have a totally different approach. They do not, for one, the lady, you don't, well, if you have it handy, 8115 is the first target. Do you have it? If you look at the new targets, the lady, you'll see that they differ drastically, because what they are, milady, and they are couched as 5-year sectoral numerical targets for all sectors. And that's at 08120, milady. And you will see on that first page, and this document running to the end of this table, milady, does, again, cover all the sectors, milady. In common with the draft targets that I was dealing with earlier, it has the same, you will see in the left-hand column, it has the same 4 tiers of employees, milady. Top management, senior management, professionally qualified, middle management, and skilled technical. And that covers an employer's employees. You see that, milady?
Yes.
And then it has, it breaks it up into male, female, across, in respect of those, milady, and then it has designated groups. So then it breaks. You'll see the 4 columns that run down have the different economic sectors: accommodation, food service, administrative, supports, activities, agriculture, and so forth. And we say, and this is not in dispute as we understand it, these sectors that are covered in this document and in the other document cover the economic field in the country. It may be very obscure, but our learned friends are not, we don't understand that to be an issue. This essentially covers the field, milady, and designated employers essentially covers the field, except for those that I indicated to you are excluded. And what it does, the significant difference is it now does not break it up into coloured, Indian, black. As you can see, it simply says designated group. That covers all of them. It does, however, have a separate, right at the bottom, milady, percentage in each case for disability only, as you see. But otherwise, it sets the targets. Now, these targets, in terms of this document, milady, must be hit within 5 years. It's not explained how, and how incremental that has to be. It's not explained what target you have to reach in year 1, year 2, etc. That would be a separate ground. It is a separate basis for attack because it is vague, lady, but that is not an attack we've taken. So I'm not going to press that. But I'm merely demonstrating, and this is crucial, as I said, to understand the case with reference to these targets rather, and the original targets that I'm going to return to in a moment. All of these, lady, are possible under this Act. Therein lies the problem. That is our fundamental problem. So it doesn't behove, our learned friends, and I don't, in fairness to them, understand that to be the approach. They don't try to say, well, look at this, these targets are fine, they're great. What's your problem? Because they can't. Because these targets are only here because of administrative, it's an administrative act. These can be pulled off the table tomorrow, my lady, during the argument of this case, or next week, or next year. And the minister can bring along other targets. He can bring back the targets that he set initially. The targets he set initially, my lady, as we plead in our finding affidavit, would have the consequence. So let's put this aside, because unless our little friends make something of it, we're not going to address this further. This is merely illustrative of the problem. But the one thing that's crystal clear is all these targets have to be hit. And if they're not hit, you can't do business with the state. Unless the minister, once again, in his gift, decides that he's going to excuse your non-compliance. And it's crucial that you understand that distinction is all in mind. Understandably, our learned friends argue, because we know what this case is about. This case is about flexibility. Whatever the state does, government does, to achieve an object that we all agree with, broad representativity of the population, it may not cross the line, may not cross the impermissible line between setting targets or goals which you hope to achieve in a structured, rational manner, and setting targets that are so rigid or so rigidly applied that they constitute a quota. That is not constitutional, primarily because of the effect it has on the dignity of those affected by the imposition of those quotas. So those principles, or the general principles at play in this case, and we all seem to subscribe to and understand. But our argument, my lady, is that the difficulty that government faces here is that here's an example of what they can do. So we set this aside, but if you go then back, my lady, to 234, which is where I was earlier, the initial draft targets, this is another example of what the minister can do. They both are permitted in terms of this legislation, and there lies the problem. So our challenge, BA's challenge, is to the legislation. Incidentally, in our notice of motion, we ask it in terms which make it clear, my lady, that the target is not the particular subordinate legislation or targets that have been promulgated in any particular case. They all, and that's why in 014, the notice of motion, we in paragraph 2 want a declaration, if you're with us, my lady, and you declare the Amendment Act unconstitutional and invalid, whether in its entirety or separate parts of it, then as a consequence of that, we ask in 2 that any enactments promulgated in terms of 15A be declared unconstitutional and invalid. And that would follow, we say, automatically, because if 15A is not there any longer, it follows any enactment in terms of 15A must fall.
But is it the entire Act, the Employment Equity Amendment Act that you want
Yes.
to declare unconstitutional, or only the sections that you make reference to in paragraph 1 of the notice?
Thank you. For clarity's sake, my lady, if we correct on the tagging, then on the authority of Kongwane, paras 109 and 110, I believe, then the natural consequence of the incorrect section being used is that the entire Act, the Amendment Act, is unconstitutional and invalid. So that's a natural consequence if you're with us on the tagging. If you're not with us on the tagging, and we get to the merits of the challenge, maybe, then it's only those sections that we ask, not the entire Act, but only those sections that we ask to be declared invalid. And it is, lady, it is, Section 15A is one of them, and we submit that 15A, if it goes, then any enactment in terms of 15A must obviously go as well. So there's no discrete and separate attack on the content of, well, we say the target speaks for itself. Milady, can I just make one last point about, and we pleaded this in our founding affidavit, and perhaps I could just take you to that. And this is apropos, milady, the initial draft targets, which was all we had to deal with. As you know, the new targets were only promulgated after our heads were filed. They were promulgated in April of this year, long after pleadings closed, long after our heads were filed, which is why they're not dealt with. But can I take you to what we said to demonstrate, milady, why this legislation is offensive and what its ability is? Because therein lies the point. So our learned friends can't wriggle out of the problem, milady, by saying, well, there's nothing particularly wrong with this version. What's wrong with this version? Wrong question, milady. The correct question is, what can the minister do in terms of Section 15A? And if the minister is given an open book and the minister can cross the line from constitutional to unconstitutional, then Section 15A is unconstitutional. That is the DA's argument. And here's what the minister can do in terms of 15A. Because the minister promulgated these draft regulations, which are DA 1 and 2 our papers. In paragraph 56 of our founding affidavit, we say the following. I just want to see whether I can locate In paragraph 56 of our founding affidavit, we say the following. The draft targets illustrated the point.
What is the measurement?
223 press lines. So, in our challenge, milady, to the legislation, you find that beginning at 221, we say it provides for a quota that sets rigid targets that must be complied with. I will return to that, milady. Ground 2 at 222, it otherwise violates Section 9. We there set up that ground. And we say that in 52, even if the impugned scheme is not a quota, it is nevertheless disproportionate and unconstitutional for the following reasons. First, it replaces the system, I've addressed that, that required every employer to formulate and implement an equity plan, tailored for that employer's unique staff complements, operational needs, and the labour market faces with a one-size-fits-all mandatory targets that are the same for every employee in a particular sector and region, regardless of how differently situated they may be. The reality is that different employers in a particular sector will have different employment needs, face different labour markets. One employer might need electricians, another might require coders, another fitters and turners. Section 15A permits the minister to lump all of these employers together and force them to hire the same specified ratio of various race and gender combinations, which is what it does. Then we say, second, the impugned scheme has the potential to create an absolute barrier to employment or advancement for members of particular racial groups in a particular area. This is fundamental to our challenge, maybe this second point. And then we elaborate on it, we say the following. The draft targets illustrate the point. Posit X, an Indian woman falling within the skilled category in the financial and insurance sectors category living in Gauteng. That you find, the lady, that we are referring to, you find at 0243. So if you go to 0243, financial and insurance sectors, you go to part 10, lady, and you go to skilled. Where's it? Oh, skilled. D is skilled. So it's the right-hand block, milady, and you run down to part 10, female, and you run across. You will see I, Indian, is 1.9%. So, in terms of that target, milady, and you will see this from these targets, and this is how these targets worked, or were conceived to work, milady. If you were a female in Gauteng working in the financial services sector and you were in the skilled category, your employer could only employ, milady, if you were a coloured female. 1.2% of the workforce could be coloured female. And Indian, milady, female, 1.9% could be Indian female. So that is how these targets were conceived in terms of 15A. And we say the following about that in paragraph 56. The draft targets applicable to designated employers operating in Gauteng would prescribe that a minimum of 82.3% of the workforce of any designated employer must be African, a minimum 2% must be coloured, a minimum of 11 must be white, a minimum of 1.7 must be Indian men. That adds up to a collective minimum of 97.4 for all of the race and gender groups other than Indian women, and thus an employment ceiling of 2.6% for skilled Indian women in the financial and insurance categories in Gauteng. It follows that it would become exceedingly difficult for ex-Indian women to find a job in Gauteng. She must find a designated employer that has not hit its very low Indian women ceiling, that needs her particular set of skills within reasonable proximity of where she lives. If she cannot do so, she must move elsewhere to find a job. And we go on. She could only really move to KwaZulu-Natal to improve her chances, given that this is the only province in which the Indian women's ceiling is higher than it is in Gauteng. In every other province it is lower. The opponent says, I do not have to belabor the point that it is an exceedingly odious echo of our history for government policy to effectively require Indian people to move to KwaZulu-Natal to look for work. And my lady, that is the nub and the crux of the case. The minister's ability to set these targets, wherever they set them, that's not the issue. But to set targets that are going to apply across the board in every case, and the only out is if you are required, is for an employer to come along and say, well, I couldn't comply because of this and this reason. And then the minister can excuse your non-compliance. But we say that is not the same at all as an act that doesn't impose unreasonable and unconstitutional burdens. All that does is that it's left to the minister in his gift to relieve you of the consequences of not complying with the minister's targets. And that is no answer to whether the targets are offensive or not. So that essentially, my lady, is the nub and the thrust of our complaint. The targets that are set in this case, the targets that may be set, given the minister's broad, unqualified powers now introduced in terms of 15A, permit, my lady, they are unconstitutional for the reasons that we've advanced in our papers and our heads. And they, we submit, cannot withstand scrutiny. They do not comply with the nuanced and flexible standard that the Constitution requires. That will way of a rather long introduction. I've got 15 minutes. I'm now going to go on to the first substantive issue, lady, which is the tagging issue. Unless the court has any questions. As the court has. So you know the tagging issue, lady, it's the question that arises is, should this have been tagged as a Section 76 bill as opposed to a Section 75 bill? The test, and it seems we are all in agreement about what that test is, and perhaps I can just take you to where the DA deals with its finding affidavits. We deal with it at 0228, already. Round 5, the incorrect tagging. And in paragraph 74, we make the contention that it must be tagged and processed in terms of Section 76 if it affects, in substantial measure, any of the functional areas in Schedule 4 of the Constitution. It's common cause in this case, already, that people is not tagged as a 76 bill, but as a Section 75 bill. And we say in paragraph 75, given how broad and intrusive the impugned scheme is in respect of the economy of each province, the Amendment Act affects in substantial measure at least the following functional areas in Schedule 4, and we then list them there. Agriculture, airports, other than international and national airports, casino, gambling, health services, goes on. That's the case, that it substantially affects those functional areas in Schedule 4. Now, the bodies don't seem to disagree, my lady, that the definitive case, the dispositive case in this regard is Kongwane, the decision of the Constitutional Court that both parties have relied on. Kongwane, my lady, has been uploaded to the authorities. It is to be found at 12-1307. Could I ask the court whether you have that? Sorry, 12-1307 is where the case begins. 12-1307. You have it, Milady?
Yeah.
Could I ask you to go to 12-1328, Milady, paragraph 49. The applicants then, referred to as the communities, Milady, and this was legislation, the Communal Land Rights Act, referred to in judgments Clara. In paragraph 49, the court, this was an unanimous judgment by CJ as it then was. The communities contended that Clara should have been classified as a Section 76 bill because it affects the provinces. They relied upon the decision of this court in Lickable. They submitted that in Lickable, this court formulated the test for the classification of bills when it held that, I quote, a bill whose provisions in substantial measure fall within a functional area listed in Schedule 4, stop quoting, must be dealt with under Section 76. They submitted that the provisions of Clara in substantial measure deal with Indigenous and customary law and with traditional leadership, which are functional areas listed in Schedule 4. In its written argument, Parliament contended that the test for tagging the bill was the substance of the legislation, which was referred to as the pith and substance test. The phrase pith and substance is borrowed from other jurisdictions and refers to what we term the substance, the purpose and effect, or the subject matter of legislation. The purpose and effect test was developed by this court to determine whether the National Assembly or provincial legislature has the competence to legislate in a particular field. Based on this test, which Parliament contended should also apply to the process of determining the manner in which a bill should be tagged, Parliament submitted that the pith and substance of Clara was land tenure. Any provision of Clara that deals with Indigenous law or traditional leadership, matters listed in Schedule 4, is incidental to land tenure. These provisions were irrelevant for the purpose of tagging Clara. And then the court goes on in paragraph 52. However, in response to questions put to counsel for Parliament in the course of oral argument, there was a noticeable shift in Parliament's position. Counsel for Parliament accepted that there is a difference between the test for determining legislative competence and the test for determining how a bill should be tagged. This case, my lady, deals with the second, not the first. He also accepted that if a substantial part of the bill is concerned with the functional area listed in Schedule 4, then the bill falls to be classified as a Section 76 bill. However, he maintained that no substantial part of Clara affected the provinces and that Clara was correctly tagged as a 75 bill. The argument suggests that in tagging a bill, Parliament looks not only at the substance or purpose and effect, but also at the provisions of the bill in order to determine whether any of its provisions affect the functional area listed in Schedule 4. And then, from paragraph 55, the Constitutional Court deals with the proper test. It says that liquor bill involved a bill introduced in Parliament. dealt with as a bill affecting provinces in terms of 76. And then the Western Cape province in this case did a bit of a cynical, it's been described in another case, I think, Judgment of Rogers, did an about turn once, and it suggested that the legislation should have been dealt with under Section 75, and based on an argument by the Minister, and not Section 76. But be that as it may, the court in paragraph 56 says the following. In resolving which section applies, 75 or 76, the court said in resolving this issue, the heading of Section 76, which is now referring to its previous judgment in Lickable. This court held the heading of Section 76, namely ordinary bills affecting provinces, provides a strong textual indication that Section 76.3 must be understood as requiring that any bill whose provisions in substantial measure fall within a functional area listed in Schedule 4 be dealt with under Section 76. It went on to hold that whatever the proper characterization of the Lickable, a large number of provisions must be characterized as falling within such a functional area, more particularly the concurrent national and provincial legislative competence in regard to trade and industrial promotion. And then, accordingly, once a bill falls within a functional area listed in Schedule 4, it must be enacted in accordance with Section 76. And then there's some debate as to whether, in saying that Lickable was purporting to lay down a test, and the court deals with that, the lady, in 58. And here is the definitive statement of the law and the ratio of Tongwane. The contention of the community is that the statement whose provisions in substantial measure in Lickable formulates the test for determining the procedure to be followed in enacting a bill must, in my view, be upheld. What matters for the purpose of tagging is not the substance, and this is crucial, believe, because of an argument that Parliament raises in its heads of argument and in its answering affidavit, which with respect to it is wrong based on this passage. What matters for the purpose of tagging is not the substance or the true purpose and effect of the bill. What matters rather is whether the provisions of the bill, in substantial measure fall within a functional area listed in Schedule 4. This statement refers to the test to be adopted when tagging bills. This test for classification or tagging is different from that used by this court to characterize a bill in order to determine legislative competence. That would involve the determination of the subject matter or the substance of the legislation, its essence or true purpose, etc. And the court repeats that in 59, and then in 60, and this is where Tongwane refutes an argument raised by Parliament in its answering affidavit, and we believe that it persists within its heads. Tagging, it says the test for tagging must be informed by its purpose, the purpose of the tagging. Now, learned friends put a lot of emphasis on that. We submit that emphasis is misguided. I'll deal with that in reply, but what's important for the moment is this. Tagging is not concerned with determining the sphere of government that has the competence to legislate on a matter. So to the extent that Parliament, in its answering affidavit, my lady, we find that at, you don't have to go there, I just want to read this to you because it demonstrates we submit the error with respect on their part. In paragraph 21 of their answering affidavit at 414, lady, after explaining why we are wrong, they say, provincial legislatures have no power to pass legislation of the foregoing kind. In other words, the Amendment Act legislation. They say provincial legislatures can't pass such legislation, and that's the reason why this cannot be legislation affecting the provinces inasmuch as it falls within the functional area in Schedule 4. But those obviously are distinct requirements. The fact that the legislation could not be passed by a provincial legislature is irrelevant as to what he's saying here. The question is not the competence of the legislature. and that you find in 60. And then, crucial to this case is the concluding statement in the final sentence in 60, where after stating the test again, the court says the following: whether the matter is to be dealt with or how it's to be determined in terms and how it's to be tagged, lady, depends on the following: depends on whether it affects the provinces. The more it affects the interests, concerns and capacities of the provinces, the more say the provinces should have on its content. And that is the approach that the Constitutional Court endorses and requires. So the test, my lady, is: does it fall within the functional area? Does it substantially, let me be accurate, lady, and use the wording of the Constitutional Court. The test, my lady, is: do the provisions of the legislation, in this case the amendment, in substantial measure fall within a functional area listed in Schedule 4? And as the court says, this statement refers to the test to be adopted. So that is the test. Do the measures in substantial measure fall within the functional area listed in Schedule 4? That is the test in Tongwani laid down in para 58. We say that's the Walsh judgment. That's given further content by what you've seen, lady, in both para 59, the concluding sentence, i.e. do they substantially, the provisions substantially affect functional areas listed in Schedule 4, and then the final part of para 60, lady, whether it affects the provinces. The more it affects the interests, concerns and capacities of the provinces, the more so the provinces should have. Now, if one looks, Melody, with respect at the legislation here, we submit that quite clearly it falls, as we pleaded, within the functional area listed in Schedule 4. In our heads of argument, Melody, at para 45, we've in fact set out a table which indicates 0728, is the empty total. You find it 0728. We set out the extent to which the Schedule 4 competences are coterminous with an overlap with the sectors that may now be dealt with in terms of Section 15A, with reference, and that are dealt with in the numerical, the targets that we've identified. Referred to. So there you would see, Milady, that agriculture, for instance, appears in both cultural matters, education, health services, etc. So in all those sectors, Milady, which are now subject to 15A, and which are at the same time functional areas within Schedule 4, the Minister may now come along in terms of this legislation, the Amendment Act, and as we've indicated before, contrary to the approach adopted before, where every employer would generate its own equity plan and that would be carefully constructed on the basis of its own considerations, the Minister now comes in with a top-down numerical goal, Melody, which can be more or less egregious, but it's all at administrative, it's all within the Minister's power. The Minister can set these targets. There's no constraint on how we should set them, and that is the number of our charge. No constraint on how the targets are set. You can set targets, Melody, which are specific to individual race groups. You can set general targets for designated groups, as is now done. You can have regard or not have regard, Melody, to the different demographic makeups of provinces, which is not done, and that's a separate ground of attack. When we get to the substance, it's not done with these numerical targets, precisely because they're not based on, or they're not specific to different provinces. And what the Minister may do in terms of the amendments is to set these targets, Melody, and to impose them employer does not meet the targets, the employer then is in breach of the Act, is in breach of compliance. The employer can throw itself on the mercy of the Minister and seek an excuse for the non-compliance. But we have addressed that to you already in resubmit, and I'll address it further in reply, depending on the answer we get from the friends. It's not the same as having that unreasonable and unconstitutional imposition or requirement imposed on it. And in the particular context of the effect on the provinces, Milady, as you would see from 53, the result of this legislative scheme is that the Minister, by imposing these national targets without having any regard to the province and with it being tagged as a Section 75 bill, where the provinces then necessarily had less input into its processing through Parliament, the National Minister gets the power to impose targets which, when it comes, since all these targets will obviously they operate nationally, which means they operate throughout the country in all the provinces. It means that in Gauteng, for instance, regardless of the desires of the provincial government there, and regardless of its own economic strategy or planning considerations, it may not, its employers, the employers located in Gauteng, may not, Milady, not comply with the requirements of the Act. And one of the squealer, which directly affects the provinces, is employers who are not compliant may not contract with the state, which includes the provinces. So as a direct consequence, Milady, of the legislation, and perhaps the most direct and obvious consequence, but the consequences are far more pervasive than that. But perhaps the most obvious consequence, most immediate and apparent consequence, is that no employer in any province, regardless of that province's own policies, plans, SCM, policy, etc., can contract with the state if not compliant with the Minister's targets, the Minister's goals. So that is the extent to which, and that's across all sectors, all those Schedule 4 sectors, Milady, which are coterminous with the sectors identified by the Minister in the targets. And we submit that effect, which this legislation has, is clearly within the Tongwane test. For a matter affecting substantially, its provisions in substantial measure, Milady, affect Schedule 4 functions. And in a substantial measure affect the interests, concerns, etc. of the provinces. And that is the reason why it should have been treated, Milady, as a Schedule 76, as a Section 76 bill, and should have been processed accordingly. If you are with us on this argument, Milady, then, as I indicated earlier, in terms of Tongwane at 109 and 110, Milady, it would follow that the Amendment Act would be unconstitutional and invalid in its entirety. A further argument, which we accept is not pleaded, Milady, and, sorry, I see it's 20 past. Would you like me to finish? Shall we take the tea? You indicated you wish to take the tea, Jim. Should we take it now, or shall I finish the tagging argument?
I'm going to argue now the 195.
I want to argue 195.
Take tea?
Happy to take tea. Happy to take tea.
Thank you.
All right.
Thank you.
057591 of 2023. My lady, I confirm that the parties are as before the chair of the committee.
You are?
I am an affected party. We tried everything to be able to gain access to the court in the minimum time we have. I'm from the Khoikhoi and Bushman community. Whatever is going to be decided in this court will affect us, and we want the court to allow us to give our position on the case.
Do you have an application before court?
We have an application ready. We couldn't, because there's no case, we couldn't get a case number, and because the court's phone numbers don't work.
When did you try and contact the court?
Your Honor, so I was the person that actually...
No, I haven't given you time to, I haven't given you permission to address me.
Okay.
When did you try to approach the court?
When was it? Must I go for? Must I answer from here?
Yeah.
Yeah, we've tried this one. And this one.
Your Worship, if I may, I was the person...
I'm not going to allow you to address me. And if you don't have all your facts, sir, then you cannot proceed to address me.
We've tried...
Just a moment. We're in the middle of court proceedings.
Okay.
What time did you get to court?
We were here at about just after 9.
So why didn't you approach us?
We tried to get hold of the court. We wanted the case number and to know more details. We've spoken to the DO also, and we tried to get through their offices the case number.
No.
So what we are asking you is, we have been sidelined by Parliament making laws without us. The court must give us a right, and we are here on the basis of customary law. We don't understand the common law. But this is a law that is going to affect our people.
I can only entertain an application that is before me. Your papers are not before me.
We can print it.
The manner in which we deal with court proceedings in this court, you must file your papers for the court to have regard to it. I must read your papers, and then you're presenting an argument before court.
I hear what you're saying, madam.
All right.
But we don't even have a case number. We have
Well, that's unfortunate because the roll gets published. The roll gets published. So everybody's got access to the roll. You see, there are lots of members of the public here. They know that because the roll was published.
Okay, I want to put it on record that we will consider this a mistrial.
That's fine. You can sit at the back, you can remain in attendance, you can listen to the proceedings, and you'll have access to the judgment of the court also once the court gives the judgment. All right. I haven't given you time to address me. I'm not going to. Let me proceed, Mr. Jamie.
As the court pleases, Milady. Milady, I was going to address you on section 1953 of the Constitution. That's a separate basis for attacking the tagging that was chosen here. Our learned friends for Parliament have elected not to deal with it. Subject to, they have put up a note belatedly this morning, which we don't object to, where they purport to deal with the contents of the submission. Before now, their position has been, because we hadn't pleaded it, we were not allowed to raise it. Now, with respect, my lady, that misconceives the position with regard to this court's consideration of matters of law. The court would know as well as I do that a court can never be bound by legal errors, if such they are, committed by the parties. So the fact that a party doesn't raise a point of law, milady, which is apparent from the facts, or indeed that a party abandons a point of law, makes a concession. The case I'm going to take you to now, the authority for this proposition, was a case where a party's counsel expressly abandoned or made a concession and abandoned a point of law. And even that, the court said, well, that can't bind us, because then we may end up making a wrong decision because of the peculiarities of the way the matter's being conducted. That's not the law. That's not the legal position, my lady, especially where the court's dealing with a fundamental constitutional issue. The question of whether this legislation was correctly tagged and thus processed is a fundamental constitutional issue and requirement that it be correctly tagged. If the court is satisfied at the end of the case that we've presented, my lady, on the facts that are common cause, that this legislation was incorrectly tagged because it is legislation contemplated in 195.3, then the court will say so. The court, it would be a game of charades and totally perverse and not in line with our constitutional jurisprudence for a court to say, no, this is clearly unconstitutional, but I can't do so because Mr. Jamie or the DA didn't raise the point. That's, with respect, not the way this works. So perhaps to get that out of the way first, firstly, we don't concede, milady, that it's not been pleaded. The matter is pleaded that the challenge to tagging is raised at 228 case lines to 229 of our papers. It is a succinct 4-paragraph challenge, milady, but we submit properly construed, para 73 is broad enough to cover both bases that we raise, milady. And we say the fifth reason is that it's unconstitutional in that it was incorrectly tagged as a bill in terms of Section 75 when it should have been tagged as Section 76 bill. I accept, because I don't like to make submissions that are factually inaccurate, milady, that we don't reference expressly 195 in what follows, and what follows we do characterize, milady, the challenge as being one based on the functionality argument that you heard me address this morning. But that is insofar as the pleadings are concerned. Parliament's answer is to be found, milady, at 0412, milady, where they deal with the tagging arguments. And that too is an admirably succinct response. They raise no facts. They merely deal with the matter on the basis that we've incorrectly understood the provision. You will see from paragraphs 16 to 26, milady, that absolutely no factual detail is provided in response. So the suggestion that had we referenced 195, there would suddenly have been a fundamentally different response, and reams of facts would have been placed before the court, which are now not placed before the court, is, with respect, milady, understandable they'd make the submission but not supported by the facts. There are no facts. And the case is a very simple one. The authority for the propositions, we've uploaded the cases onto case lines, milady. I'm going to give them to you briefly. It's Barkhuizen versus Napier, decision of the Constitutional Court, at para 39, where the court makes the point that the mere fact that a point of law is raised for the first time on appeal, which is not the case here, we're raising it here, milady, but even if it's raised on appeal for the first time, is not in itself sufficient reason for refusing to consider it. If the point is covered by the pleadings, and if its consideration on appeal involves no unfairness to the other party, this court may, in the exercise of its discretion, consider the point, and then unfairness may arise, for example, where the facts might have been otherwise had the issue been crisply and squarely raised. And authority for that proposition, milady, is inter alia the case of Paddock, Motors v. Ingersoll, the 1976 decision of the appellate division as it then was. The Paddock decision, milady, makes the salient point, and it appears that was not uploaded, so I apologize for that. We will, with the court's leave, upload it, milady. But the authority is Paddock Motors, Pty Limited v. Ingersoll, 1976-3, SA 16 at AIM, brackets AIM, milady, and it's at pages 23 to 24. And at 23, Johnson J.A. makes the following point, which we submit as the point, is the authority for the submission I just made to you. With reference to what Innes J. said in Cole v. Government of the Union, a 1910 case, Johnson J. 23D to E says the following, milady: for this reason, the raising of a new point of law on appeal is not precluded, provided certain requirements are met. If the point is covered by the pleadings, and if its consideration on appeal involves no unfairness to the party against whom it is directed, the court is bound to deal with it, and no such unfairness can exist if the facts upon which the legal point depends are common cause, or if they are clear beyond doubt upon the record, and there is no ground for thinking that further or other evidence would have been produced had the point been raised at the outset. in presence of these conditions, a refusal by a court of appeal to give effect to a point of law fatal to one or other of the contentions of the parties would amount to the confirmation by it of a decision clearly wrong. And that's an extract from Inez J. in Cole's case, and then in Paddock the court goes on that it would create an intolerable position if a court were to be precluded from giving the right decision on accepted facts merely because a party failed to raise a legal point as a result of error of law on his part has also been accepted by this court in Van Rensburg v. Van Rensburg. And that, my lady, is the position in law. And at page 23, letter H, the court deals with the facts of that case where in fact there was a concession as to the law point and says, does that make a difference? And then answers the question, I think not. So even in the face of a concession, the court will not be constrained or not refuse to deal with the point of law. The last reference I'm simply going to give you is a more recent constitutional court authority, my lady. It is Botha v. Smuts, square brackets 2024, ZACC 22, my lady. And it is at Paris 63. So those are the legal arguments. Then getting to the thrust of the matter, my lady, there are two scenarios in terms of 76.3 where a matter must be dealt with in terms of 76 and not 75. The first is the one you heard me address earlier, and that is, does it fall within a functional area? The second one is this, my lady. Or provides for legislation envisaged in any of the following sections. And we highlight section 76.3D, my lady. That is the reference to sections 195.3 and 4 of the Constitution. So if the legislation deals with a matter envisaged in 195.3 or 4, it must be dealt with and tagged as a section 76 bill. Now, 195, my lady, 3, the one we rely on, says, national legislation must ensure the promotion of the values and principles listed in subsection 1 of 195. Do you have that handy, my lady?
Yes, I have it.
So that is 195.3. National legislation must ensure promotion of the values and principles. The one we rely on specifically for purposes of the argument, my lady, is 195.1 195.1I, my lady, which is the requirement in the Constitution that public administration must be broadly representative of the South African people with employment and personnel management practices based on ability, objectivity, fairness, and the need to redress the imbalances of the past to achieve broad representation. Now we say, indisputably, it's not a matter of rocket science. That is what the Employment Equity Act deals with, my lady, and that is what the amendment deals with. And if we're correct in that submission, which we submit we indisputably are, then that is the short answer to this case, because then it is legislation contemplated in 195.3, read with 195.1I, my lady. It clearly, and then you do not get into the more complicated aspect that I addressed this morning about functionality, my lady, and why it does intrude into a Schedule 4 function or functions. It's a crisp question. Is it legislation that is dealing with public administration, the need for public administration to be broadly representative? And does it seek to redress the imbalances of the past to achieve broad representation? I invite my learned friends, I've seen their argument and I'm going to address it briefly, but with respect to use the pith and substance language which is not appropriate to tagging in relation to Schedule 4, my lady. The substance and pith of this legislation is quite clearly those matters. If the court were to be left in any doubt as to that, then we reference the preamble to both to the Employment Equity Act, my lady, which I asked the court to make a note of when I began addressing this morning. Namely, one of the purposes of the Act is to achieve a diverse workforce broadly representative of our people. That is a verbatim repeat, my lady, in material part of the requirement of 195(1)(I), broadly representative. So this is clearly such legislation, and thus it must, my lady, have been promulgated as a Section 76 Act. In response to that, and any other arguments I'll deal with in reply, but one of the responses our learned friends put up in the note this morning is they say, no, this legislation is not the legislation contemplated in that section, in 195(3). I don't know whether you've had a chance to look at the note, my lady.
Came very late.
It did, but
Take me through it.
we forced ourselves to look at it before argument, my lady. And one of the points our learned friend raises is, no, you're wrong to make this argument because the Amendment Act is not the legislation contemplated in 195(3). But the problem with that argument is our learned friends appear to consider that there is only one piece of legislation that 195(3) is envisaging, which is dealing with the values and principles set out in subsection 1 of 195. But that isn't and can't be the case. If you consider the list of values and principles in 195(1) quite clearly, my lady, unlike, because I think where my learned friends get the argument from is Chapter 3, the Bill of Rights, where when there's a right conferred, it very often says national legislation must be enacted to give effect to the right. And then we're used to arguing in litigation about rights, my lady, that, well, clearly, so for instance, the Section 33 legislation envisaged in the Constitution is PAJA, and the access to information legislation is PAIA, and so forth. And it's quite clear what the legislation is. That's not the same construct and approach here, my lady.
But I think let them make the argument first.
Should I deal with it in reply?
And then you deal with it in reply. I'll give you that time.
Happy to do that. So then I'll leave that there. So that's our argument with regard, my lady, to the tagging. We submit clearly what 76 should have been complied with. That's the end of the case if you're with us. Now to the substantive challenge.
If you have 30 minutes more.
I have 30 minutes.
Let's just, there's no other
Interruption.
interruption.
I should finish in 30 minutes, my lady. I've managed to cover a fair amount of the ground in the opening remarks we made, my lady. So I'm hoping not to have to repeat that. We've dealt with a number of the cases, and we submit that the cases, my lady, and I've explained to you our understanding, and not our understanding, sorry. I've explained to you our characterization of the pre-amendment legislation and the amendment, and how it achieves a fundamentally different, or it seeks to achieve a very different approach. And we know from the Minister's answering affidavit, the Minister says, well, we're not happy with the pace of transformation. And that may well be a legitimate concern of government, but the question is, how do they seek to address it? And we say that by imposing one-size-fits-all, top-down, blunt, rigid targets, my lady, and I emphasize rigid, which can only be excused, it's important to keep in mind this distinction I've made a few times. It's not missing the target that's being excused. What's being excused by the Minister's power to nonetheless, or to not take steps against you is the Minister says, well, you've got a good reason for non-complying. But you, as a matter of fact, you are non-compliant. So you are in breach of the Minister's targets. And therein lies the difficulty we submit constitutionally, that the targets are rigid. The targets, and as I'm going to demonstrate, the targets are not only rigid, they are blunt, my lady. So the first problem we have is they're blunt. There's one target set per sector, and once again, you will keep in mind, I'm not attacking the specifics of the targets, my lady, that you have before you in terms of the supplementary affidavit this morning.
I've made that distinction already. We attack, milady, the power that's given to the minister to make, for example, such targets. And the problem is the ability to set targets that are entirely blunt, entirely rigid, which would operate, milady, regardless of demographic makeup of particular provinces, and which would have to be met under pain, inter alia, of not being able to do business with the state, and various other sequelae that would follow from non-compliance with legislation, unless excused by the minister, which is within his gift. And in the setting of the targets, the way the minister, we know there's provision, you'll hear from our learned friends, he's got to consult with, etc., various people, but how the minister arrives at any particular target, and you will appreciate, milady, in the absence of directions and guidance in the legislation, not the regulations. My learned friends no doubt will say, look at the regulations. But regulations themselves are, you can't interpret. It's a basic proposition, milady. You don't interpret the constitutionality of legislation with reference to the subordinate legislation. Precisely because the subordinate legislation doesn't come from Parliament, it can be pulled away, replaced at the drop of a hat. So it doesn't assist our learned friends to refer to Regulation 16. We accept that there are indicia there as to how the minister must exercise his discretion to excuse you, but that doesn't assist in our principal complaint that there's no guidance in the Act by Parliament as to how he can excuse you and on what basis. So that is left entirely within the minister's gift. You can do it for good reason, bad reason, or no reason. Arbitrary, capriciously, etc. And therein lies the constitutional complaint that we raise. So that's the context of our case. Now, the relevant, we've referred, milady, to, and our learned friends have referred to this, these cases as well. And the starting point, milady, as to unfair discrimination is Hodgson v. Lane, a case that we've referred to, milady. And the test that Hodgson v. Lane lays down is to be found, milady, in the so-called three-prong test laid down in Hodgson v. Lane, milady, is not Hodgson v. Lane. Okay, sorry, let me just the test is the one laid down in Van Heerden. I apologize for that, milady. But could I first take the call to Hodgson v. Lane, milady, which we have referred to? We've referred to our heads, milady, and specifically to para 51 thereof. And this is a case decided under the interim constitution, but its provisions are in material part, milady, the same as section 9, the equality provision at issue here. And the court in that case at para 41 says the following: the prohibition on unfair discrimination in the interim constitution seeks not only to avoid discrimination against people who are members of disadvantaged groups, it seeks more than that. At the heart of the prohibition of unfair discrimination lies a recognition that the purpose of our new constitutional and democratic order is the establishment of a society in which all human beings will be accorded equal dignity and respect, regardless of their membership of a particular group. Of their membership of particular groups. And then that's para 41, milady, of Hugo, which is being referred to in Hodgson. And then para 43 from the same judgment, Hugo, to determine whether the impact was unfair, it is necessary to look not only at the group who has been disadvantaged, but at the nature of the power in terms of which the discrimination was effected, and also at the nature of the interests which have been affected by the discrimination. And then in Hodgson, the court summarizes that by saying the following, and we submit this is important, milady, in your consideration of this matter. the court says, the prohibition on unfair discrimination in the Constitution provides a bulwark against invasions which impair human dignity or which affect people adversely in a comparably serious manner. So, with that being said, my lady, if I could then go to Van Heerden, once again a case that we've cited in our learned friends too. And the so-called Van Heerden test, the threefold test, you find at paragraph 37 of the judgment, my lady, where the court explains that when a measure is challenged as violating the equality provision, its defender may meet the claim by showing that the measure is contemplated by section 9(2) in that it promotes the achievement of equality and is designed to protect and advance persons disadvantaged by unfair discrimination. It seems to me that to determine whether a measure falls within section 9(2), the inquiry is threefold. The first yardstick relates to whether the measure targets persons or categories of persons who have been disadvantaged by unfair discrimination. The second is whether the measure is designed to protect or advance such persons or categories of persons. And the third requirement is whether the measure promotes the achievement of equality. So that's the Van Heerden test, my lady. That was a case, the court will recall, where there was a challenge by an old order MP to the new parliamentary pension scheme in respect of parliamentarians. And the argument, my lady, was that that was discriminatory to Van Heerden, who was a white old order member of parliament. And the court found that it was not, my lady. And the court, in fact, finds that, but there we are dealing clearly with a specific policy, my lady, the pension policy, and also with a particular complaint against the policy, which, as I've emphasized, is not the case here. But the court, under consideration of the facts, inter alia, my lady, that the new plan to address imbalances and past discrimination in respect to pensions was for a limited period, and that old order MPs continued to receive outstanding pension benefits, found that the scheme did not constitute unfair discrimination. The next case that is relevant, my lady, is Barnard. Once again, we've referred to the case in our heads, as has our learned friends. That was a case, again, an individual complaint brought by, I think she eventually was Colonel Barnard. She was a white female captain when the litigation commenced, my lady, and she was not promoted in a particular case, and she brought an action inter alia based on unfair discrimination. Now, the claim was dismissed, my lady, at paragraph 60 on the basis that it wasn't correctly pleaded. So what then follows in Barnard, on our understanding, would strictly be arbiter, but nonetheless, it's a judgment of the full court, constitutional court, my lady. Well, sorry, it's a majority judgment by Moseneke, AECJ as he then was. So we submit the case is certainly of persuasive value, my lady, notwithstanding that it is strictly arbiter. Now, what the court does, my lady, in Barnard is to refer to, and that is a case that did deal with this case that's dealing with Business Act. No, but it deals with this Act. Yep. This case does deal with this Act, my lady, the Employment Equity Act. And what the court does is, with reference to the Employment Equity Plan, which we've referred to, the court will recall earlier I referenced the equity plan, my lady. The court says in paragraph 6, I'm sorry?
Paragraph?
Paragraph 66 of the judgment, my lady. Sorry, do you have it?
I have the judgment. I didn't know which paragraph you're on.
Certainly, paragraph 66, my lady.
Thank you.
The court says, now, obviously this is the Employment Act and the Equity Plan prior to these amendments, Milady. So in that regard, the court says the Employment Equity Plan obliged the National Commissioner to take steps to achieve the targets, provided he acted rationally and with due regard to the criteria set by the instruction. He was within his right and indeed duty to take steps that would achieve the set targets. It is so that the implementation of a valid plan may amount to job reservation if applied too rigidly. But was that the case here? For several reasons, I do not think that the National Commissioner pursued the target so rigidly as to amount to quotas. And then the court goes into a factual consideration which is not relevant here, milady. But what is relevant is the court's approach in that passage to pose the question, well, was a plan which may be fine in conception implemented in a manner which amounted to job reservation and quotas? Because if it was, it would fall foul of what the Constitution requires. We are not at that stage for the reasons I've explained. We are at the anterior stage. We're looking at this without reference to any particular complainant before you. The court appreciates that. So we are looking at it from a, maybe called an abstract challenge. But there's nothing wrong in doing that, because if the legislation is of the sort we say it is, then it falls foul of the Constitution. Not because of its application, but of its conception. Now, that is dealt with, milady, that conceptual issue in para 54 of Barnard, and I ask the court to go there. Where the court deals with this very question of what is not permitted, apart from the facts, what is not permitted in terms of legislation, and the court says the following: let it suffice to observe, that is in para 54 toward the end of the passage, milady, if you have that. Let it suffice to observe that the primary distinction between numerical targets and quotas lies in the flexibility of the standard. Quotas amount to job reservation and are properly prohibited by section 15.3 of the Act. You'll remember I took you to that this morning, milady. This Act itself in 15.3 prohibits quotas. It says you can have girls but not quotas. And that's what the court is referring to. Are properly prohibited by section 53. The same section endorses numerical goals in pursuit of workplace representativity and equity. They serve as a flexible employment guideline. And I ask the court to emphasize and perhaps underline, if you could, milady, the word guideline. Because this is the pre-amendment landscape of what the Act allowed and required. The goals which an employer was supposed to set in its equity plan, which I've explained came from consultation, etc., milady, were flexible enough. They served as guidelines that the employer would try to achieve within the realm of its operating circumstances, its employees, their makeup, because remember, the requirement is suitably qualified, not anyone. We're talking about substantive equality, not just dress, window dressing. We're not looking, the Act doesn't seek window dressing, it's just that we tick the numbers. It's not a number ticking exercise or box ticking exercise. It's substantive equality. So the people must be able to do the job who are appointed. And it's in that context we say that the Constitutional Court characterizes the Act as this is the requirement, it's a guideline. What we now have with the amendments is it's crossed over. It's no longer a guideline, as I've been at pains to emphasize. It's now clear these are targets that must be met. If these targets are not met, one, no work from the state. Across the board, national, provincial, municipal. Two, if you don't meet these targets, you are in breach. Three, if you don't remedy it, you can be fined. Now, to meet these targets, milady, if you are an employer, what do you have to do? It may be necessary, milady, to meet the target that you may have to get rid of people. You may have to fire people because they're the wrong color, they're the wrong group. You may have you may have a workforce which is broadly representative, milady. There may be some specific aspects in terms of which it doesn't meet the particular targets, but that they would be broadly representative of the South African community or the South African population, but they would not meet the minister's targets, and that would be in breach, milady, the Minister could then find you in breach. And once again, this is all milady, in terms of legislative powers that are given in the broadest and vaguest of terms. And we've emphasized it's not, the strictures within which the Minister must operate are not laid down in the Act. And that, of course, as we've pleaded, I'm not going to take you specifically to that, is a breach of the requirements laid out in the Dawood judgment, which we've referred to in our heads. In Barnard, milady, the court expressly finds in para 66 of the judgment, this is the majority of the court, milady, that the manner in which the manner in which it had been implemented was not such, I've read that to you, so as to amount to the imposition of a quota. The minority judgment, milady, of Cameron, Furneman and Majid, it is a minority judgment, but it, with respect, gives a powerful indicator of how a court should approach the question, milady, of whether there's been unfair discrimination in any particular case. The court there, per Cameron J, says the following. Having in 118, milady, deal with the judges deal with a court giving deference to how decisions are made, because the court accepts that you engage in a balancing exercise when applying Section 9, milady, and the Act. And decisions, and occasionally hard decisions, have to be made. The court appreciates that. It deals with that in 118. And then in 119 it says the following. This is so because Section 9 of the Constitution and 15.4 of the Act mandate a holistic approach to an employment equity plan, one that accords with the Act's requirements and objectives. To do otherwise, again, this is the pre-amendment landscape, milady, to do otherwise would be to sanction rigidity that would convert the numerical targets specified in the plan into impermissible quotas. For instance, an overly rigid interpretation of the numerical targets could have adverse effects for Indian or colored people. The plan's ideal target for Indian women is 0.4 employees or fewer at every salary level. Now, I hasten to add that is not obviously the scenario with the current targets, that is the previous targets. But herein is what the court says about those targets, which I again emphasize is possible under this statutory regime, which is why the statutory regime is unconstitutional. The court says, the plan's ideal target for Indian women is 0.4 employees or fewer at every salary level. An overly rigid approach to the plan would require that the National Commissioner never approve the appointment of an Indian woman. That would not only be absurd, it would be a bitter irony, because Indian women have also suffered past discrimination. And therein lies the danger and the problem, milady, with this legislative scheme. Solidarity was a case that was argued and brought, milady, under this Act, the Employment Equality Act. The majority judgment by the then, he wasn't the Chief Justice, by Zondo J, as he then was, milady, set aside the equity plan that had been developed, milady, or rather, set aside decisions not to promote 10 employees, 9 of whom were coloured, in the Western Cape, who worked for the Department of Correctional Services. policy of, and the plan, milady, of the department in that case was found to be unconstitutional because it did not take into account, milady, the fact that, or rather it did not take local demographics into account, more particularly the makeup of the economically active population in the Western Cape. Instead, it imposed national demographics, and the court finds that that is unconstitutional, milady. But in para 56, the court makes the following observation, which we submit is relevant. The court references Barnard, milady, which I've just referred to in para 51, and it says that for the applicants to show that the numerical targets constituted quotas, they need to first show that they were rigid. And the applicants submitted the targets were rigid and were applied rigidly. And once again, milady, I'll deal with any answer in reply, but I just want to draw the court's attention, without taking you to it exhaustively, of the manner in which the court evaluates in solidarity, milady, whether there's been constitutional compliance with the equity plan they had issued. The court deals with, milady, from para 74 on to para 79. And it finds on the facts there that the application was unconstitutional. But the relevance of these paragraphs is, we submit, that the court makes it quite clear that in considering compliance with the Employment Equity Act and the plan, the court has regard to the way in which and the basis upon which the individual employment equity plans have been formulated, milady, in order to address, in the manner required by the Act, broad representativity based on considerations that are specific to individual employers. And we repeat, milady, that approach, which is endorsed by the Constitutional Court in solidarity, is fundamentally at odds with the top-down approach, which the amendment now countenances. And we submit that that is not what the Constitution requires. If I could then just briefly, milady, refer you to the Saripa judgment, milady, which we've also referred to in our heads of argument. It's Minister of Justice and another v. South African Restructuring and Insolvency Practitioners Association. The judgment is at case lines 12896, milady. And that was the SCA judgment. The SCA judgment, milady, you will recall, dealt with a policy which had been developed by the master for the appointment of provisional liquidators. And in assessing that, whether that complied, milady, with the requirements of Section 9, the court makes the following point, and this is pivotal to our case, milady, and I ask the court to have regard to para 32 of the judgment at 12909. And this is what the court says in Saripa. In particular, as stressed by Moseneke J in para 41 of Van Heerden, which I referred to, milady, when dealing with remedial measures, it is not sufficient that they may work to the benefit of the previously disadvantaged. In addition, they must not be arbitrary, capricious, or display naked preference. If they do, one can hardly be said to achieve the constitutionally authorized end. One form of arbitrariness, caprice, or naked preference is the implementation of a quota system. Now, I have no doubt my learned friends are going to argue vigorously this is not a quota system. I don't want to debate that. The court has said, and you know from the Act, that quota is not defined, my lady. So, quota is not defined, but that does not mean that something that isn't strictly a quota is, by definition, constitutionally okay. It isn't, because there's a second part to what the court says in Saripa. It says, one form of arbitrariness, caprice, or naked preference is the implementation of a quota system, and then it goes on, or one so rigid as to be substantially indistinguishable from a quota. And that's the second part, my lady. To be a quota, or something that is so rigid as to be indistinguishable from a quota. And we submit that what the Amendment Act permits, as I've said repeatedly, is, because it's open-endedness, because of the absence of any Darwood constraint in the Act itself, my lady, the Minister is given carte blanche. The Minister has an open, a clean slate. The Minister can set any targets he likes. And those targets, my lady, can, as they do here, if you read them with the other amendments, Section 20, Section 53, they can be so imposed rigidly, my lady, as effectively to amount to a quota and to provide an insuperable barrier to progression for someone who's not, who doesn't fall within the designated group. And therein lies its offensiveness. And we rely upon this passage, my lady, in Saripa, para 32, the court goes on to then say, after what I've just quoted to you, this explains why Section 15.3 of the Act permits preferential treatment and numerical goals but disallows quotas. And then, on an analysis of the scheme at issue there, it finds, my lady, that this in fact did amount to an offensive constitutional scheme. I have, I think, 2 minutes left, and I'm going to try to wrap up. I just want to make the point, my lady, that there was a judgment, which is part of the cases we've cited, in the Constitutional Court, but from Saripa, my lady, but it did not, the court did not, or the court set aside the scheme on a different basis, namely that persons of color born after 1994 were also excluded from being beneficiaries. So it doesn't touch the reasoning, it doesn't criticize in any way change the reasoning or judgment of the Supreme Court of Appeal and the passage I've just referred you to, my lady. And in conclusion, our case, my lady, is Section 9 prohibits discrimination. Section 9.1, my lady, says everyone is equal before the law, has the right to equal protection and benefit of the law. Section 9.2 is the provision that permits so-called affirmative action. It says that to promote the achievement of equality, legislative and other measures designed to protect or advance persons or categories of persons disadvantaged by unfair discrimination may be taken. But that notwithstanding, my lady, it goes on in 3 and 4 and 5 to deal with unfair discrimination. It says the state may not unfairly discriminate directly or indirectly against anyone on one or more grounds, including the grounds that are listed there, my lady, which covers obviously race and gender. Sub 4, no person may unfairly discriminate against anyone directly or indirectly on one of those grounds. National legislation must be enacted to prevent or prohibit unfair discrimination, and discrimination, sub 5, on one or more of the grounds in sub 3 is presumptively unfair. Now, all of those provisions stand in tension, my lady, to the constitutional provision to be found in 9.2. And how that is to be resolved is a matter for the court to decide. We submit that, as I've said at the outset, no issue with the idea, we can't have an issue. The idea encapsulated in 9.2, milady, it's how you achieve it. We submit that the Employment Equity Act in its previous unamended guise struck a correct balance in the way that it addressed the question. We submit that the Amendment Act does not. It crosses the line. It impermissibly allows the minister to impose a one-size-fits-all, which is precisely what he's done, scheme. And that's all we need to say about it. It gives the minister, we submit, it gives the minister the ability, milady, to impose a one-size-fits-all scheme. Whether he chooses to do it or not in any particular case is not the test. The constitutionality or otherwise of legislation does not depend on the caprice of a minister who is required to implement the legislation. So if the legislation is unconstitutional, which we submit it is, then no particular rendition of regulations or targets can save it from that. And that is the case that we advance. For those reasons, we submit that we are entitled to an order in terms of the notice motion.
Okay, thank you.
Yes, we see costs, milady, but in line with BioWatch, if we are on the losing end,
The other side.
we submit that we should be immunized against costs.
Okay,
As God pleases.
thank you. You said you're going to take how long?
An hour and a half at most.
At most. So you've got half an hour before lunch.
As the court pleases.
Thank you.
My lady, this case is not about discrimination against anyone. The Amendment Act does not seek to advantage anyone unfairly or impermissibly so. It is an application of what the Constitution requires of all of us as a nation, as a people, to make sure that those who have been previously disadvantaged by discrimination in the workplace in particular, they are fairly equitably represented at all levels of management or the running of the business, but also that they are advanced in their dignity, and that what previously we endured as a country, where people of color could not advance beyond a certain point in the workplace, that should be a matter of the past. So to that extent, this is an affirmative action measure which is legislated, which is also permitted by the Constitution. What we will argue is that the measure is constitutional on any count. It meets all the constitutional validity requirements that have been laid out in our jurisprudence, and it cannot be set aside or attacked on the basis of not meeting a constitutional requirement. The central argument that the applicant wants to make is that this measure will create quotas which are prohibited by the Employment Equity Act. We say, no, that is not correct. In the first place, it does not refer to a quota if one does a grammatical analysis of what the provisions say, and even read in the context of the entire legislation, even in its amended form. There's no quota either as required or as defined by the constitutional courts, by the constitutional court in the various judgments. The measure is flexible because it talks about targets. And so we'll argue that on any conception of the standards laid out by our laws, jurisprudence about how to evaluate the constitutionality of a measure, legislation, that it passes all those tests. We will also argue that there's no violation from the Dawood principle, that the Act introduces a measure which is placed in the hands of an executive, the minister, to do that which is allowed to do in terms of the amendment, the purpose of which is to support affirmative action, as he is entitled to, as in fact is enjoined to do so. One thing that must be borne in mind, my lady, is that we're not dealing here with the targets which were drafted at the time when the matter was started and which have gone through various iterations. That is not the basis of the arguments that the leadership or the decision that leadership must make. The question centers on the legislation itself. Does 15A contravene any of the constitutional requirements? Not the targets which have been set out. 15A creates a framework. 15A is not the targets themselves. And so one cannot transpose what the targets say in either draft forms. That because the targets as constructed favor this or that grouping, that therefore that means that the section 15A itself is unconstitutional. One must distinguish between the legislation itself and its application. You may apply it in a way that is constitutionally unacceptable, but that does not mean that the legislation itself is unconstitutional. And so we are not going to argue, the leadership is not required to argue the demographic profile argument that the applicant has raised about the example of the Indian lady who wants to apply for a job in Gauteng, but because the quotas, as they call them, have been exhausted, that lady must now move to KZN. That argument is not available on the pure issue of whether the legislation itself, not its application, whether the legislation itself is unconstitutional. Some of the leading cases which the parties have referred to, Barnard, Solidarity, they dealt with the application of an employment equity plan. And in certain senses, the court would say, no, the plan has been applied properly. In other words, in other cases, they will say, no, it hasn't been applied properly, depending on what the equity plan says. But that does not mean that the 15A regime is itself unconstitutional. What I propose to do, my lady, is to take the court through the structure of the Employment Equity Act in its amended form. And the submission we'll make is that the legislation, the amendment has just added one element in the whole issue of measuring employment equity over time. And the importance of what the government seeks to do is to be able to track progress. If you can't measure it, you can't manage it. If you don't know what targets or goals you want to reach to in 5 years' time, how will you know when you arrive there? And what the applicants are saying is that in the previous regime, pre the amendment, these matters of equity were employer-driven. And they are saying, leave it to the employers to do as they please. Let them do and comply with the affirmative action measures as required by the Employment Equity Act. But don't interfere with what they do. They will set their own targets. They will set their own measurement principles and standards, but don't interfere in their target setting measures. And that's why we're saying there's nothing constitutionally impermissible for an executive, for the minister, to set sectoral targets, because this issue of targets is ingrained in the Employment Equity Act itself, even without the amendments. So the concept that numerical or sectoral, numerical targets that we set and goals that we set is something which is inherent in the pre-amendment legislation.
What section deals with that in the Employment Equity Act as it currently stands.
Yes, so 15 deals with, but I'm saying in the sense of who deals with, who sets the goals. So I'm saying the principle of setting goals, numerical goals, is not something which has not been done before.
Yes.
The difference is that it was done by the employees, and then they would then submit their equity plans to the Ministry of the Party. So now, what the Act does, Amendment Act, is to put an extra layer. Say, while you are free to set your own numerical goals, we as the minister will consult the entire sector in which you operate. We will then, in consultation with you and others in your situation, arrive at targets which operate for 5 years. And so it does not take away the power and the functions which the employers had to set employment equity plans.
That remains.
That remains. And so to simply say, I will now be able to set goals for the sector. And why am I doing that? Is because legitimately as a government, we must be able to measure whether legislative interventions we have made are doing what they're supposed to do, to take people from a lower level and rise them over time so that the workplace can be democratized. It is a legitimate government goal for the minister, for the government to say, there is slow progress in democratizing the workplace, in making sure that people who were previously disadvantaged do not find their way in certain echelons of employment. To say that top management of the big employers, 50 plus, do not represent the demographics of the country, that is a legitimate goal which is enjoined by the Constitution. And to therefore say, I'm going to set targets, and we will say the fact that targets can be set by the minister doesn't make them rigid or inflexible. It depends how they are set, and it depends how they are applied. So the framework simply says the minister can set the targets. If the targets have not been set properly in compliance with the basic requirements of 15A, then we can come and have an argument on another day in this court to say whether or not the targets that have been set adequately address what is being sought to be done. But that is not why we're here. And so the applicants should not conflate the targets and the framework which creates the targets. The framework is legitimate. It is in line with the Constitution. It is in line with what the basic functions of a Minister of Labor and Employment should do. Now, let's look at the structure of the EEA, of the Employment Equity Act. And I would like to draw the attention of the court to Section 15 in its unamended form. It talks about affirmative action measures, and it says in sub 2, affirmative action measures implemented by designated employer must include, and it lists a whole number of measures, A, B, C, D. And then 3 says, the measures referred to in subsection 2D include preferential treatment and numerical goals. In other words, employers must set numerical goals as well, but exclude quotas. Then it says, subject to section 42, nothing in this section requires a designated employer to take any decision concerning an employment policy or practice that would establish absolute barrier to the prospective or continued employment or advancement of people who are not from designated groups. So this is not an oppression of others who are not designated groups. It doesn't say because you don't belong to the designated groups, you will never ever be employed. Because that if your policy, if your EEA plan does anything of the sort, to say because you may be, because you are white, you will therefore don't even bother to apply. simply because you are white. That would be an absolute barrier. And the section 15.4 in its amended form prohibits that kind of conduct. So to bandy around phrases like we are going to have to fire and hire people in order to meet the targets is not in line with what 15.4 has not been amended. It stands as it is. It stood then and it stands now. So that's 15. Now, this is what the legislation seeks to do. 15A. 15A simply introduces an added element. It does not say that employers will no longer be allowed to do their own employment equity plans. It does not say employers will no longer be required to comply with 15.1.4. It does not say that employers can now hire and fire people in order to comply with the target. It doesn't say that. 15A simply says determination of sectoral numerical targets. And if I may pause here, one of our central pieces of our argument is that every minister, every executive, every organ of state is bound to act within the strictures of the Constitution. So if a minister goes into a 15A process, they are not excused from comply with the other constitutional requirements that they have, legality and all that. So this is what a minister is not going to be allowed to do. Determination of sectoral targets. The minister may, by notice in the Gazette, identify national economic sectors for the purposes of this act, having regard to any relevant code contained in the standard industrial classification of all economic activities published by Statistics South Africa. 2, the minister may, after consulting the relevant sectors and with the advice of the Commission, for the purpose of ensuring the equitable representation of suitably qualified people from designated groups at all occupational levels in the workforce, by notice in the Gazette, set numerical targets for any national economic sector identified in terms of subsection 1. And if I may pause, we have seen 15.3 says an employer must set numerical goals. So the concept of setting targets or goals is not by and of itself repugnant. And you can't say because the minister can set targets, therefore that is unconstitutional. That cannot be so. The 15A2 puts strictures about what the minister must do. One of the things is he must consult the relevant sectors. So he won't just wake up and say, I'm not going to set targets at 100%. Can't do that. He must consult. And what are the targets for? Is for the purpose of ensuring the equitable occupational levels. So it's for affirmative action purposes. A purpose which is legitimate and constitutionally validated and legislated. So he can't just say, I'm going to set targets because I like them, as you suggested. He just wakes up and says, I like these targets, I'm going to set them. These are the strictures within which a minister will be allowed to set the targets. And 15A3, a notice issued in terms of subsection 2 may set different numerical targets for different occupational levels, subsectors or regions within a sector, or on the basis of any other relevant factor. So the minister will have to look at various occupational levels, subsectors, and may set numerical targets that differ. It is not a one-size-fits-all. The minister will have to look at the real situation on the ground to say, in this subsector, what are the representations? Are the people who are underrepresented or not? Just like in 15, in its unamended form, an employer will have to do what is required in section 16. And 16 is still there. It has not been touched. So an employer must consult with the employees, and in 16.2, the employees or the nominated representatives with whom the employer consults in terms of section 1A and taken as a whole must reflect the interests of employees from across all occupational levels of the employer's workforce, employees from designated group and employees who are not from designated group. So the minister does not do anything different from what Section 6. Section 16 still stays, and the minister simply goes about setting targets sectorally because he's got a broader view of the different sections of the economy. But most importantly, a minister can't just arbitrarily wake up and set the targets. In terms of 15A, you must draft a notice and issue it in terms of Section 1, Section 2, and publish in the Gazette, allowing interested parties at least 30 days to comment thereon. We know for a fact that, in this case, that targets were drawn in 2023 or so, they were commented on, and they've undergone various iterations. And they've now concretized into, because the minister had to do what they have to do. If you are not happy that the minister has consulted adequately, you don't attack 15A. You attack the consultative process. If you think the targets are irrational and they discriminate against one party or another, you don't come here and say 15A is unconstitutional simply because it allows the minister to set the targets. You go to the targets and deal with them that way. And so 15A does not create a new and revolutionary regime which sort of supplants the employers, take them out of the equation, and makes the minister into something like a dictator. Now, the unamended version, the unamended form of the Employment Equity Act has got assessment of compliance. The DG can still, well, firstly, the employment equity plans must be submitted to the DG every year and their annual requirements. And the DG can assess whether the employment equity plan complies with the legislation, or at the very least complies with its own numerical goals. If an employer says, I've set myself numerical goals to increase the representative top management to 5, and they submit it to the minister, the department, the DG will say after a year, well, have you done what you said you have, what you yourself said you are going to do? And if you haven't, there may be penalty, sanctions. So the idea that you may be sanctioned for non-compliance with the Act is not created by the amendments. It has always been there. If you don't comply, you could be sanctioned. The Act even talks about if you are dealing with the state in terms of contracts. That's nothing new. What the Act has done is to simply add a second layer to say, in addition to complying with your own numerical goals, you should comply with the sectoral goals, which will not be set in a random, arbitrary, or capricious manner. Now, where is the quota there? Is there a quota simply because if you don't comply with what you said you're going to do in your Employment Equity Act, you may be sanctioned? That can't create a quota. The mere fact that the sanction does not create a quota. The sanction has always been there, and there's never been any complaint about that. Some of the sanctions include going to court. If the DG makes a recommendation to an employer to say, you are non-compliant, and the employer continues not to be compliant, there is a level of checks and balance, which would be in the form of the labor court. And the
now, a review of the DG's decision. Will that be in our review of the DG's decision?
Indeed, you can review the DG's decision. If the DG acts capriciously and say you are not compliant,
yes,
you give the DG your employment equity plan. You also give the DG how you have complied with the employment equity plan. And the DG says, no, you haven't complied. You can say, but DG, you can call a meeting with somebody in the office, the DC. Here's my plan. I said I'll appoint 4 designated members to the top management. Here are the appointments. And so it's not something that can just happen capriciously. And in any event, the issue that these are targets which are inflexible, which are a blunt instrument. Section 42 in its unamended form, in 42.4, it says, in any assessment of its compliance with this act or in any court proceedings, a designated employer may raise any reasonable ground to justify its failure to comply. And the Constitutional Court in Solidarity, where it was looking at a specific employment equity category, the police said, but that employment plan has got within it grounds and opportunities for deviation. So if you don't comply, tell us why. The examples that have been bandied around that, well, somebody might be forced to leave the province and go elsewhere to look for a job because the so-called quotas have been exhausted, is not borne out by the act. And if an employer says, I have set myself the goal to employ 5 people in the top management, but I've not been able to do so. I advertised, I didn't get the necessary quality of people who must have qualifications. Because simply because of affirmative action, it doesn't mean that if you don't qualify, it's like employing me to be a plumber. I mean, I can't be a plumber. So if the employer says, I applied and Nalani applied as a plumber, but I can't appoint Nalani, this is the reason why I couldn't appoint him. It's a reasonable explanation. You will not be visited with a blunt instrument of pulverization that you'll now be fined and be deprived of state resources and all that. So the compliance mechanisms remain, they've always been there, even when the system was employer driven. Nothing is going to change. In fact, what is going to change is even for the better. One looks at section 53, the amendment. It says, the minister may only issue a certificate in terms of subsection 2 if the minister is satisfied that the employer has complied with a numerical target set in terms of section 15A that applies to the employer. B, in respect of any target with which the employer has not complied, the employer has raised a reasonable ground to justify its failure to comply as contemplated in section 42.4. And C, the employer has submitted a report in terms of section 2. So there has always been room in terms of section 53 unamended that if you are gunning for a state contract, the state might require you to comply and furnish them with proof that you have been complying with the Employment Equity Act. Section 53 simply makes it easier, administratively. It says, if you want to go to submit your tender, I can give you as a minister a certificate which says you are compliant. But where you can't comply, you must tell me. That is flexible. That is not a quota. That is not inflexible. And so the argument that suddenly the minister is creating a new regime, which is a blunt instrument, and it applies inflexibly, is not supported by the facts, but by the reading of the legislation and the structure of the entire legislation. In Solidarity, the issue was about the South African Police Services, the specifics of the employment or the active employment plan, and the court found that it provided for deviations, and therefore, if it provides for deviations, it cannot be unlawful. It is not a quota. I'm told it's 1 o'clock, my lady. Would it be the convenient time to take the lunch?
How much time do you want to take for lunch?
I'm fine.
You're fine.
Half an hour will be fine.
Half an hour for you.
Half an hour.
Would it be fine? Half an hour?
We'll take the half an hour, my lady.
Because we don't want to run out of time. Is it okay if it starts? Is it okay if we take half an hour? Okay, we're going to adjourn for lunch. We'll reconvene in half an hour's time. Thank you.
confirm that this is still case number 057511 of 2023. I confirm that the parties are before the adjournment. Thank you, Lady.
As the court pleases, my lady,
Thank you, Mr. Nalani. You may proceed.
just to round off on the flexibility point,
Yes.
we were given by way of a supplementary yesterday the targets that have the regulations and the targets which have been set, and they are at 13. But the part that I want to refer to is 13-16.
Yes.
There's paragraph 2 which says sectoral numerical targets in terms of section 15A2 of the Act for the purposes of ensuring the equitable representation of suitably qualified people from designated groups at all occupational levels in the workforce. The numerical targets for the economic sectors identified in terms of section 15A1 are set out in the table below. 2.2, the targets set out in this notice are operative from the date of publication. And then 3, implementation of affirmative action measures. For purpose of clarity, it is stated that 3.1, the 5-year sectoral numerical targets set out in this notice are not intended to add up to 100%, as a sectoral numerical target excludes white males with no disabilities and foreign nationals as part of the workforce profile. But the point is for 5 years. So it's not indefinite, and that's part of the flexibility which is embedded in the targets. And then 3.2 says the manner in which designated employers must take the targets into account in applying affirmative action measures is specified in the Act, the General Administrative EE regulations and codes of good practice issued under the Act. The importance is that the Act still remains, and as I've submitted to your leadership, that one of those provisions in the Act which says you cannot put absolute barriers, it still applies. So one must have a look at that section. This is 15.4. So you must apply the Act, which would include 15.4. Then 3.3, a designated employer will not incur penalties on or any form of disadvantage if in the assessment of compliance of affirmative action in any workplace it shows that there are reasonable grounds for not complying with the EE targets. This mirrors what the Act says. If you can't comply, you must, and you can show reasonable grounds why you can't comply, then you will not be penalized. These targets, the draft ones and the ones that are now promulgated, were used in aid of the argument that the powers that the minister has are broad, they are vague, they don't give strictures and guidelines as to how those powers must be exercised. And that the minister can wake up, do one thing today, tomorrow do something different. That in itself is illustrative that the powers are so vague and too broad that they don't meet the Dawood principle and all those principles. But the point is, a minister of government is an executive who is charged with enforcing legislation. One cannot give guidelines, as one does, to a functionary in a department about how they must exercise their discretion. An executive is empowered in terms of the Constitution to carry out the functions of running a department and implementing policy of government, including drafting legislation, regulations, and all those instruments.
But it must be within the confines of
Indeed,
the law.
indeed. He can't just wake up and say, well, today my targets are X, tomorrow the targets are Y.
Yeah.
And so we're saying the use of the targets are not in issue today. But what we're saying is even the little that one can see in the targets, in the instrument creating the targets, is that it is flexible. It's got a 5-year period. It says if you can show reasonable compliance, you will not be penalized. But if the applicants have a problem with any other aspect of the targets, they can mount a new action, and that matter will be determined elsewhere. But that doesn't mean that the Section 15A regime is unconstitutional. The mere fact that one can abuse a provision doesn't mean that the provision itself is unconstitutional. There's a judgment which was drawn to our attention during the break. It's Hermanus Frederick van Rooyen. It's a judgment of the Constitutional Court case CCT 21/01. I'm told that during the break my colleague was able to upload it at 11-30. And we want to quote one paragraph from that judgment which illustrates the point we're making. Is at paragraph 37 at page 11-58. And this was a judgment penned by Chaskalson, CJ. 37, any power vested in a functionary by the law or indeed the Constitution itself is capable of being abused. That possibility has no bearing on the constitutionality of the law concerned. The exercise of the power is subject to constitutional control, and should the power be abused, the remedy lies there and not in invalidating the empowering statute. That really makes our case that the fact that the minister might chop and change is nothing, does not mean that the power granted to the minister in terms of Section 15A, that power and the empowering provision itself becomes unconstitutional. And we've made the point, we've compared to the unamended version and the amended version that numerical targets still remain, and that employers must still have to prepare their employee plans, and that there's no harm of those disfavored. It does not visit any undue consequences to those who are not designated in the sense that they are black. It doesn't say if you're not black, you may not be employed or you will suffer some form of harm. And just if I may just return to the Dawood principle. Dawood had to do with a functionary who was working in the Department of Home Affairs and was responsible for issuing or withdrawing permits for foreigners to be in the country. And the legislation then, I think it was still called the Aliens Act at the time, did not guide the functionary how they must either grant or refuse or withdraw a permit to a foreigner who is in the country unlawfully. And so the court said it is too broad. The functionary is not legally trained, and so you must give them guidelines of sorts. And so the Constitutional Court said, go back and rework the legislation so that that functionary can know when they have to stamp or not stamp an application for a permit. But that can't be equated to a minister in a department who has a DG, who has functionaries, who has legal advisors, who has got a whole department and the machinery behind them. And then to say to them, when you are setting targets, we are going to tell you chapter and verse about what you must do and not do. The Constitution is there to guide the execution of that mandate, and they must consult, and if they consult, they can exercise their function. And I think we have dealt with the issue of approach to constitutional invalidity of legislation. I'm just returning briefly to our heads of argument, just to make sure that we have cleared and dealt with all the points. At 0912, we deal with the constitutional invalidity of legislation, and we quote at 21, paragraph 21, from the new National Party of South Africa versus Government of the Republic of South Africa and others, where the court held that the rational connection test is the standard of reviewing legislation. The first of the constitutional constraints placed upon Parliament is that there must be a rational relationship between the scheme which it adopts and the achievement of a legitimate governmental purpose. And you submitted that the governmental purpose is set out in the EEA Act itself, as well as the amendment provisions. It is all towards the purpose of affirmative action. And then the court said Parliament cannot act capriciously or arbitrarily. The absence of such a rational connection will result in a measure being unconstitutional. There's been no evidence or substantive submission to prove that there is no rational relationship between the scheme and the achievement of a legitimate governmental purpose. And on that score, the legislation is constitutional muster. The other issue, other point that one has to look at in determining whether legislation is constitutional is constrained, is the Bill of Rights. And here there is no, of course, the rights in the Bill of Rights can be limited, but in this case, there is no suggestion that the amendment infringes on any of the fundamental rights in the Bill of Rights in the Constitution. On the contrary, it is founded on the rights to equality. And this is why the amendment has been done. So it meets the strictures and requirements of constitutionality and legality. We have dealt with the topic at 9:15, the interpretation of the Employment Equity Act. We have taken the court through the various sections in order to demonstrate that it is not a blunt quota, it is not inflexible, it meets with the requirements of our jurisprudence. We've also dealt with how monitoring has to be done, and of course the arbiter and the tribunal of last resort is the courts. If you're not happy, as it has happened in many cases that have been reported, where a particular employee is not happy with an Employment Equity Act in a plan, in their sphere of work, and if they are not happy, they can go to court. And sometimes they succeed, sometimes they don't. We have dealt with the amendments. And at 65, 63, 09.34, we have submitted that the Amendment Act in Section 15A scheme is a remedial measure contemplated in Section 9.2 of the Constitution and is therefore not unlawful. We have dealt with, we submit at paragraph 68, 09.36, that the three-pronged test in Minister of Finance and another versus Van Heerden is met. And what the applicant seems to complain about is the implementation and not the substance of the 15A regime. The 939, we've dealt with no violation of the Dawood principle. I've just alluded to that. A functionary in a department is not equivalent to a minister. And then we deal with the demographic profile argument, where it is suggested that a person might have to relocate to another province because the quotas or standards or targets have been met in the one province. We've demonstrated that that is not the case, and that no one can place absolute barriers on the employment of anyone, even non-designated persons. And we quote from the Constitutional Court in Solidarity and Others versus Department of Correctional Services, where the court said, a workplace or workforce that is broadly representative of the people of South Africa cannot be achieved with an exclusively segmented workforce. For For example, a workforce that consists of only white and Indian managers and thus excludes colored people and African people, or a senior management that consists of African people and colored people only and excludes white people and Indian people, or a senior management that has men only and excludes women. If, therefore, it is accepted that the workforce that is required to be achieved is one that is inclusive of all these racial groups in both genders, the next question is whether there is a level of representation that each group must achieve, or whether it is sufficient if each group has a presence in all levels, no matter how insignificant their presence may be. In my view, the level of representation of each party must broadly accord with its level of representation among the people of South Africa. It would be unacceptable, for example, for a designated employer to have a workforce of 500 employees, 50 of whom occupy senior management positions, but only 5 of those senior management positions are held by African people, when 20 are held by white people, 15 by colored people, and 10 by Indian people, despite the fact that the population of South Africa, in the population of South Africa, African people are by far the majority. Such a workforce could not conceivably be said to be broadly representative of the people of South Africa. And that is what the legislation seeks to do. Let me pause before I just take a few minutes to find out if and then I'm reminded the solidarity judgment from which we've just quoted now. It dealt with flexibility as well. I just want to draw the court's attention to that judgment. It's at 12-1170. 53. Once it is accepted that the 2010 EE plan contained a provision for deviations from the targets of the plan, then, in my view, the targets cannot be said to be rigid.
Which paragraph?
Paragraph 53, my lady. Yes. Once it is accepted that the 2010, let me give the court a chance. Is the court there?
Yes, thank you.
Thank you. Once it is accepted that the 2010 EE plan contained a provision for deviations from the targets of the plan, then, in my view, the targets cannot be said to be rigid, particularly where it cannot be said that the situations in which deviations are permitted are situations that do not occur in reality. The evidence given at the trial on behalf of the department revealed, for example, that scarce skills included cases of candidates who are doctors and those who are social workers. A department such as the Department of Correctional Services must have a need for many social workers. Deviations could be made in regard to, among others, posts for social workers and doctors. So as long as there are deviations, and then we have submitted that there's no rigidity or any blunt force in the judgment. And in closing, this case and the amendments are about equal opportunities, not favors for designated people. In the words of the founding father of our nation, he said when he was being sentenced in 1964, "I've cherished the ideal of a democratic and free society in which all persons live together in harmony and with equal opportunities. It is an ideal which I hope to live for and to achieve, but if it needs be, it is an ideal for which I'm prepared to die." Underlining equal opportunities. We are still in that battle, in that struggle of creating equal opportunities for all members of our society, to we the people, as the Constitution says. And this is but one peg in that effort to create equal opportunities for all. As a court, please.
All right, so you're seeking the dismissal of the application. You're seeking a dismissal of the application.
Indeed. But as far as costs are concerned, of course, the BioWatch applies as a commodity.
Thank you. Manager?
Thanks, my lady. I'll be addressing the tagging issue.
Yeah.
And as the court is aware, we prepared a note for argument and a case. We uploaded an additional case, and I beg leave, it's just for the convenience of the court, if I can hand up. I've marked them with the case line page numbering.
All right, thank you. Thank you.
So, my lady, I'll follow the structure of the note for the court to follow my argument with ease. So we shall address three main topics and then conclude with on relief. The first is to look at what the DA actually pleaded on the tagging case, because contrary to our learned friend for the DA, it's important that the court knows what case Parliament was called upon to answer. And then secondly, I shall deal with the proper test for tagging and why the DA fails on that test. And then I'll deal with the section 1953 case, which we say was not pleaded, and the court ought not to consider that case. But if the court were to consider it, it lacks any merit. And contrary to what our learned friends submitted earlier.
He says he needs not have pleaded it because it's a question of law.
Well, yes, I'll come to that. But I was going to say, my learned friend said we simply argued that it wasn't pleaded and we don't even address the merits. We did so in the main heads, and we also did in the note, which I'm going to address the court on.
Yeah.
And then in conclusion, we will submit that the application should be dismissed the BioWatch principle applies, so they will be saved from the costs. If I can start off with the case that the DA pleaded, that the court will find at paragraph 73 to 76 of the founding affidavit for the Democratic Alliance. And it's headed ground 5, incorrect tagging. It says 73, the fifth reason that the Amendment Act is unconstitutional is that it was incorrectly tagged as a bill in terms of Section 75 of the Constitution when it should have been tagged as a Section 76 bill. You will see that simply tells you what case they are bringing. They are not pleading any basis to challenge the tagging yet. Then 74 says, I'm advised that a bill must be tagged as a Section 76 bill and follow the procedure in Section 76 of the Constitution if it affects in substantial measure any of the functional areas in Schedule 4 of the Constitution. If a bill that should have been tagged as a Section 76 bill follows the Section 75 procedure, it is unconstitutional and invalid. So they tell you the legal principle on which they bring the case. It is that if it affects in substantial measure any of the functional areas in Schedule 4 of the Constitution, then it should be tagged as a Section 76 bill. What is the case they bring? They've told you what they intend to do. They've told you the legal principle. Now they plead the case at paragraph 75. They say, given how broad and intrusive the impugned scheme is in respect of the economy of each province, the Amendment Act affects in substantial measure at least the following functional areas in Schedule 4 of the Constitution. So their case is based on the application of the principle they've identified at paragraph 74. And those functional areas they identify as agriculture, airports other than international and national airports, casinos, racing, gambling and wagering, health services, industrial promotion, media services directly controlled or provided by the provincial government, provincial police, population development, provincial public enterprises, public transport, provincial public works, tourism, trade, urban and rural, child care facilities, firefighting services, tourism, municipal airports, municipal health services, municipal public transport and pontoons, ferries, jetties, piers, and harbors. And then in 76 they say, given that the amendment was tagged as a Section 75 bill when it should have been tagged as a Section 76 bill, it is unconstitutional and invalid. Can I just state the obvious? When you've read this 4 paragraphs and you've got one paragraph that pleads the case, the court can't conclude that reliance on Section 76.3 and 195.3 is covered by the pleadings, by the founding affidavit. There is no mention of Section 76.3 and Section 195.3. Not even the principle of that section, let alone the mention in the section, is not covered. That's the founding affidavit. And paragraph 73 can't be read in any other way to include a reliance on Section 195.3 of the Constitution. It's just telling you what the DA intends to do. Well, let's assume the court was benevolent with the DA. One was prepared to look at the replying affidavit. Does the replying affidavit raise a Section 195 attack? My lady will find the replying affidavit in respect of Parliament at page 05-11 at paragraph 42 to paragraph 43. It says, paragraph 42, I deny that the Amendment Act does not trigger the application of Section 76 of the Constitution, based on the pleading that they have made in the founding affidavit. Over the page, my lady, at paragraph 43, they say, in the Western Cape government's commentary on the draft targets, it was raised that the bill had been incorrectly tagged. I annexed a copy of its presentation marked DA8. Even if the court was still furthermore benevolent and was to look at the annexure to see whether the annexure refers to Section 195, my lady will find that the annexure only refers to Section 9.2 and Section 217 of the Constitution. Not even in the submissions is Section 195 relied upon. So there is nothing on the papers before the court which would cover any reliance on Section 195 of the Constitution. So there is nothing there. But in addition, my lady, I've read paragraph 75 of the DA's founding affidavit, where it says the scheme of the Act affects in substantial measure the functional areas in Schedule 4, which they then list. Even at that level of pleading, you're not told how the Act, the scheme impacts those functional areas. Nothing. You're just told it does. We must wait for my learned friend to stand up and tell us how. That's the first time we know of the case that the DA is making. To what extent that those functional areas are affected, the DA tells no one. So we submit with respect that that is the case. The full extent of the DA's case is paragraph 75 of its founding affidavit. That's the case that Parliament was called upon to address. And against that, my lady, I tend to deal with the proper test for tagging and why we submit that the DA fails the tests. In the main heads, my lord, we deal with that from page 10 to 22. I'm not going to take the quote there. I'll stay with the note. Page 11-2, paragraph 8 is when we start to deal with the test. My lady, the test is common cause because that is set out in Tongwane. The test for tagging, we quote from paragraph 60 at the foot of page 8. The test for tagging must be informed by its purpose. It is not concerned with determining the sphere of government that has the competence to legislate on a matter. And the paragraph 58 of the judgment, which our learned friend referred to, which says you look at whether the Act affects in substantial measure functional areas in Schedule 4, which is the case that we are called upon to meet. That is the test. But the cases don't always tell my lady, they don't guide my lady as to how does one determine whether an act affects in substantial measure a functional area in Schedule 4. There's a useful judgment of His Lordship then Rogers J, as he then was, which we referred to, the Western Cape High Court, paragraph 9 of the note, that concerned the e-toll legislation and whether it affected in substantial measure functional areas in Schedule 4. And writing for the court, Rogers J, as he then was, quoted, summarized an argument that was presented by the DA's counsel in that case. And I'll quote from there, that's from paragraph 694 of that judgment. It says, the DA's counsel in written argument placed considerable reliance on the 5 questions suggested by Mari and Simeon at 256 to 259 of the article cited in footnote 1 supra. That article was written before the decision in Tongwane. It was mentioned in the Tongwane judgment in passing. Mr. Domini, that was the DA's counsel, in oral argument accepted that to the extent that the approach suggested by Mari and Simeon is in conflict with Tongwane, I'm bound by the latter decision, by the Tongwane decision. I do not find it necessary to comment on the author's discussion of the first 3 questions they pose as part of the test for tagging. In other words, trying to determine whether there's an impact in a substantial measure on functional areas. Those 3 questions all appear to be concerned with provisions of a bill which actually regulate a Schedule 4 matter. However, and we underline that, and to the extent that their 4th question indicates, as I think it does, an approach which would require knock-on effects to be taken into account in tagging, I respectfully part company from them for all the reasons I have given. So he says the test is not determining whether the Act has a knock-on effects on a functional area. The test is what he says in the last paragraph. I thus conclude that in accordance with what I have called the direct regulation approach, the substantial measure test for tagging laid down in Liquor Bill and Tongwane requires 1, to determine whether, to a substantial extent, the legislation under consideration actually regulates matters falling within Schedule 4. If it does, the bill must be tagged under Section 76. If not, the bill is to be tagged under Section 75, even though the implementation of the legislation on the matters falling outside Schedule 4 may affect the social, economic, and other circumstances relevant to the regulation of the matters listed in Schedule 4. So what the judgment says is the substantial measures test in Tongwane requires this court to undertake an assessment of whether the Amendment Act actually regulates any of the matters they list in paragraph 75, which they say are Schedule 4 matters. If it does, then it would affect those matters in a substantial measure. If not, it wouldn't. And we haven't had argument that that articulation of the substantial measures test and its application is inconsistent with the Tongwane judgment. It is in line with that judgment. It is the correct test. Now, in its heads of argument, and we say that at paragraph 10 of the note, the DA contends that Section 15 capital A empowers the minister to regulate the demography of specific sectors listed in the Standard Industrial Classification of All Economic Activities, the SIC, and the demography of all economic activity in South Africa, including trade. Let's accept that that is the case. The Section 15A regulates demographies, or the remaking of demographies as they want the court to, they submit to the court. Demographies of sectors and the economy are not functional areas in Schedule 4. So there is no, the impact of the Act on demographies is irrelevant for purposes of the inquiry on whether there's an impact in substantial measure on Schedule 4 matters, because that's not a Schedule 4 matter. Then the DA contends further that the sectors listed in the SIC are coterminous with or fall within or overlap with many of the functional areas in Schedule 4 of the Constitution, illustrated by the table at paragraph 45 of their heads, and it says trade is a functional area in Schedule 4. Let's take those matters listed in 45 and understand what the DA is really telling the court. If my lady turns to paragraph 45, you'll find a long list of the functional areas they rely on: administration of indigenous forests, agriculture, all of that, and trade is included. So what they're saying, and I exclude trade for the moment, I'll come to trade specifically because they then make an argument specific to trade. If I can just stay with all the others other than trade, they're saying that Section 15A, they're saying the sectors listed in the SIC overlap with the sectors in Schedule 4. Well, yes, because the SIC covers all sectors of the economy. But how does that advance the DA's case? The DA must show you that Section 15A has a substantial, affects the listed areas in a substantial measure. I've taken my lady to the Rogers J judgment. They must show you that the Section 15A regulates these matters. Now, Section 15A regulates employment equity within those sectors. Let's take agriculture. It regulates, it says these are the targets in the agricultural sector that you must achieve, but it by no means regulates agriculture, which is the functional matter that is listed in Schedule 4. It doesn't regulate agriculture. And the carrying out of the activity of agriculture, the enterprise of agriculture, is unaffected by whether you have 10 white men or 15 black men. Gender and race are irrelevant to how the trade is carried out. Because unless you're going to assume that employment equity means employing people that are underskilled and are not suitable for the job, but that's not what the Employment Equity Act says. So you must assume that those the demography of in the workplace is a demography that is suitable for that job. Now, if one accepts that, then there is no impact on efficiencies of that enterprise, nothing. So firstly, you have legislation that doesn't regulate agriculture, and what it regulates can't be assumed to impact either negatively or in a substantial manner the way in which the enterprise is carried out. And you can read for all of the others, education, all of them, the Employment Equity Act does not regulate the enterprise, the activity, or the matter which is listed under Schedule 4. So it can't impact that matter in a substantial manner. It can have knock-on effects on that sector, as Justice Rogers acknowledges in that passage that I've read to my lady at paragraph 9, that he says, it says, if not, the bill is to be tagged under Section 75, even though the implementation of the legislation on the matters falling outside Schedule 4 may affect the social, economic, and other circumstances relevant to the regulation of the matters listed in Schedule 4. That doesn't pass the test if it simply has these effects, because those are just knock-on effects. So that is not. So when they say they are coterminous and they overlap, the listed activities under the SIC overlap with those in Schedule 4, it tells the court nothing about the application of the substantial measures test. All it says is that Section 15A covers the field, as our learned friend said. It covers the economy. Of course. It covers the economy because the Constitution requires in the preamble and in Section 9 to that transformation must touch all of society, all of South Africa, all of the economic activity. No corner of South Africa should be left not attached by the transformational goal of the Constitution. So with great respect, and we deal with that at paragraph 12, we summarize the points about why they don't show the test, they don't meet the test in respect of substantial effect on Schedule 4 matters, because all that they do is to show an overlap between the SIC listed activities and the Schedule 4 matters that they rely on. But that's not the point. As our learned friend said, and we agree and we've said so, we are not confused. The test for tagging is different from the test for determining which sphere of government is competent to legislate on a particular matter. So the listing of matters on its own would be good enough if that's all we were debating. But because we're looking at tagging, the question is a little bit more substantial. So for our learned friend to say to my lady, it's obvious. My lady, if cases were obvious, we probably wouldn't have clogged up rolls and all of that, because they are not obvious. And there is a test to be met. And that test must be met on the pleadings. And I've demonstrated by reference to paragraph 75 of the founding affidavit that the DA said not a single word on how, in fact, Section 15A substantially impacts those listed matters, other than that they overlap and they are coterminous. So we summarize that in paragraph 12. I want to deal with trade separately, because here our learned friend for the first time, and you won't find it in the heads of argument nor in the founding affidavit, singled out Section 53 of the Employment Equity Act as amended and said, that section says if you don't get a certificate showing that you comply, you may be refused to contract with the government. But with respect, we need to go back to the section and see what the section says. So the important thing here, before I go to the detail, my lady, is recall my lady is concerned with the tagging of the amendment bill, not the tagging of the pre-existing act. So it is the tagging of that portion of Section 53 which is in blue, and not Section 53 which is in black, because that is the pre-existing act which was passed through a Section 75 process. Then DA maybe didn't have sharp legal representatives at that time, but didn't raise this as a Section 76 bill at the time. And there were subsequent amendments which were also not raised as Section 76 bills. But what does Section 53 says, my lady? It says, and I'm reading from 08-154, that is under the general provisions. Section 53 deals with state contracts. It says, 1, every employer that makes an offer to conclude an agreement with any organ of state for the furnishing of supplies or services to that organ of state, or for the hiring or letting of anything, A, must, if it is a designated employer, comply with Chapters 2 and 3 of this Act, or Roman 2, if it is not a designated employer, comply with Chapter 2 of this Act, and B, attached to that offer either Roman 1, a certificate in terms of subsection 2, which is conclusive evidence that the employer complies with the relevant chapters of this Act, or Roman 2, a declaration by the employer that it complies with the relevant chapters of this Act, which, when verified by the Director General, is conclusive evidence of compliance. Subsection 2, an employer referred to in subsection 1 may request a certificate from the minister confirming its compliance with Chapter 2 or Chapters 2 and 3 as the case may be. 3, a certificate issued in terms of subsection 2 is valid for 12 months from the date of issue or until the next date on which the employer is obliged to submit a report in terms of Section 21, whichever period is the longer. 4, a failure to comply with the relevant provisions of this Act is sufficient ground for rejection of any offer to conclude an agreement referred to in subsection 1 or for cancellation of the agreement. 5, the Minister may, in the Code of Good Practice, set out factors that must be taken into account by any person assessing whether an employer complies with Chapter 2 or Chapter 3. So the prohibition against dealing with the state if you don't comply already existed before the amendment, as you can see, my lady, from Section 53, sub 1 to 5. What does the amendment do? All the amendment does in subsection 6 is, firstly, it says when will the minister issue the certificate. So it's regulating how the minister issues the certificate. When he must issue, if he's satisfied that A, the employer has complied with a numerical target set in terms of Section 15A that applies to that employer. And B, in respect of any target with which the employer has not complied, the employer has raised a reasonable ground to justify its failure to comply as contemplated by Section 42(4). This echoes my learned friend Mr. Lanali's repeated argument to the court, my lady, that there is flexibility in this Act about compliance. It is not rigid, it's not a guillotine. And C says the employer has submitted a report in terms of Section 21. D, there has been no finding by the CCMA or a court within the previous 12 months that the employer breached the prohibition on unfair discrimination in Chapter 2. And E, the CCMA has not issued an award against the employer in the previous 12 months for failing to pay the minimum wage in terms of the National Minimum Wage Act. So all that the amendments do is regulate when the minister will issue the certificate. The amendment itself does not regulate contracting with the state. Contracting with the state and the prohibition is in the pre-existing legislation. So how then does subsection 6 regulate trade or contracting with the employer? In a substantial measure, other than merely saying, the minister, you've got a power already, and there's a prohibition already. When you issue the certificate, here's the guidance. They have been saying all this time in their arguments, this legislation is so vague, it provides no guidelines to the minister. It gives the minister carte blanche. Here the legislature has sought to constrain that power of the minister by saying you will issue the certificate under these 5 conditions, if you're satisfied that these 5 conditions are met. So there is no regulating of trade here. They should have, at the time when the Act, Section 53, that was in 2013, my lady, when subsection 5 was introduced, subsection 5 was only introduced in 2013, so the previous sections probably existed from 1998 when the legislation was first passed. They could then have said, there's a functional area being affected, functional area of trade is contracting, that is trade. But with great respect to our learned friends, there is nothing obvious. In fact, there is no case in respect of the tagging case based on the functional areas in Schedule 4. My learned friend tries to say, well, also if it affects in a substantial way matters of interest to the provinces. You won't find that allegation in the founding affidavit. But in what way? You're not told, because the founding affidavit does not develop a case of that kind at all. The founding affidavit is very clear. It tells you the principle in paragraph 74. It tells you the case in paragraph 75. It concludes. The reply says, we stand by that case. We've always raised tagging, and nowhere does it raise any more grounds than the grounds in paragraph 75 of the founding affidavit. Now, my learned friend, I'm going to get to 195.3 in a moment, but I just want to flag, there was a long discussion of cases on appeal where an appeal court can decide a law point if it is apparent from the papers. So if it's covered by the papers, the court can decide it, even if one of the parties omitted to raise the issue. Because as the Constitutional Court is said in Kusa and Tawu and versus Kusa, the court cannot permit a judgment to stand based on an illegality. So if that's the judgment was wrongly decided because a law point apparent on the papers was not decided, An appeal court can't ignore that. Firstly, you're not on appeal, my lady. You're dealing with the court. This matter is a court of first instance. But secondly, the issue of section 76.3 and 1953 is not covered on the papers. That's the simple point. So even on those appeal judgments, we would make the argument before the appeal court that there is no indication on these papers at all that case is being mounted. That's why my learned friend said, but you can read paragraph 73 broadly, but there's nothing in 73 other than to tell you that they're going to challenge the tagging. That's all. But the case comes at 75 with respect. So we submit that on the substantial matters argument, measures test, the DA fails woefully to make out a case. And it's because it knows that it failed to make out that case, even at the level of pleading, that in the heads of argument, it comes up with this new argument about section 195.3. And my learned friend makes it out to be purely a section 195.3. It's not just a 195.3. You read 1953 with section 76, and you must say what part of 76 you rely on. Recall here it says they rely on 76.3D. Sorry? I think that's right. If I can just look at that, if I'm right. Yes. Sorry. 3D. Yes. Yes, but so he must refer to 76.3D. I think we've quoted the relevant parts of that section in the note, my lady. I can just refer the court to that. My lady will see that just the page before. Yes, page 11-6 at paragraph 15, we make the point that they now try to make a new case. And the attempt now is to rely on 76.3D and 195.3. So you've got to say 76.3 provides as follows in relevant parts: a bill must be dealt with in accordance with the procedure established by either subsection 1 or subsection 2. If it provides for legislation envisaged in any of the following sections, then it lists a whole number of sections. You must say, I'm picking D, so you must plead your case. And then also, once you've picked D, you must also pick whether it's 195.3 or 195.4. You can't just leave it as that. And they just did not plead that case. And they said, well, the court must be flexible. There's no hard and fast rule. My lady, even the Constitutional Court has emphasized the importance of pleadings. Unless there is a reason on fairness which requires that rule to be relaxed. And we will point out that, in fact, fairness here works the other way. Because as my learned friend said, if you find that 195.3 applies, then the whole act falls, the whole act. Not even one section or this section, the whole Amendment Act falls. That's a significant prejudice to Parliament to meet a case for the first time in the heads of argument, not even in reply, my lady. And then secondly, one will ask, what is the prejudice to the DA if that they're not permitted to run a case that they plead for the first time in their heads? There's no prejudice. They've challenged the Act. They've listed all the sections that they're not happy with. If they are correct in their challenge, those sections will be set aside. So they will lose not even a litigation advantage because they have challenged the whole Act. And they've also challenged the tagging, but on a different ground. So if they are right on the specific challenge to sections, or they are right on the part that they actually pleaded on the tagging, they suffer no prejudice. If they are wrong, they are wrong. They lose. The parties lose in court because the Act is constitutional. But, my lady, there is a judgment we do not refer to in the heads on this question of the obligation to plead your case. And I just want to add that, and we will upload it to case lines. It is Minister of Local Government, Environmental Affairs. Oh, we've uploaded it. My learned colleague has uploaded it to 11-198. 11-198. I want to refer, my lady, to paragraphs 38 and following of the judgment. It deals with, paragraph 30. It deals with the question whether what was pleaded on the challenge to the validity of legislation. And it summarizes that. And then 35 deals with the failure to challenge the constitutionality of the particular provision. And it says that paragraph 35, this court enjoys a wide jurisdiction when deciding a constitutional matter within its power, is obliged to declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency. That being said, this court has time and again reiterated the importance of challenging the constitutional validity of legislation in a manner that is accurate, timeous, and comprehensive. Unless considerations of justice and fairness require otherwise, parties must be held to their pleadings. It is not for this court to troll through the record and submissions in the hope of finding a means of assisting a litigant. At paragraph 38, my lady, it quotes from the judgment of Prince. It starts off at paragraph 37, but at 38 it says, however, he explained that, and it quotes from that what was said by Ngobo J as he then was in Prince. It says, in quote, parties who challenge the constitutionality of a provision in a statute must raise the constitutionality of the provisions sought to be challenged at the time they institute legal proceedings. In addition, a party must place before the court information relevant to the determination of the constitutionality of the impugned provision. I would emphasize that all this information must be placed before the court of first instance. The placing of the relevant information is necessary to warn the other party of the case it will have to meet, so as to allow it the opportunity to present factual material and legal argument. My learned friend repeatedly said, what are the facts? What are the facts? Factual material and legal argument to meet that case. It is not sufficient for a party to raise the constitutionality of a statute only in the heads of argument without laying a proper foundation for such a challenge in the papers or the pleadings. The other party must be left in no doubt as to the nature of the case it has to meet and the relief that is sought, nor can parties hope to supplement and make their case on appeal. That is on all fours with this. And then we refer also to other constitutional court judgments, my lady. At paragraph 20 of the note, we refer to the Geleke judgment, where the Constitutional Court emphasized that duty on parties to make out their case in founding papers. It held in Geleke Kanse, this is not to stamp in this, we quote, the Democratic Alliance on technical points. It is to insist that a litigant should stick to the case it has set out in its challenge. If it has no faith anymore in the challenge it has actually pleaded, it must adopt a different course. 21, we say Parliament was denied the opportunity to deal with a case based on sections 76(3)(d) and 195(3) of the Constitution in its answering affidavit and on the basis of the contentions now advanced in the DA's heads of argument. As the majority in my vote counts held, my lady, even in open and shut cases, which is, our learned friend says this case is obvious, even in open and shut cases, Parliament was entitled to such an opportunity. And it will suffer prejudice, and I have addressed this prejudice because it was denied the opportunity, and the whole of the Act must fall by the wayside because of the latter day argument raised only in the heads of argument. And by contrast, there's no prejudice to the DA. It has brought its constitutional challenge and chose the grounds on which it relies, advised by counsel, experienced counsel, my lady. And my lady, a reliance on section 76(3) and 1953 is just not a matter of saying from the bar. It's a matter of pleading. And we've given my lady a case, a constitutional court judgment in Samu case. It's footnote 20. It is now in the we've now uploaded it to case lines. It's the second copy that I handed to my lady. It's that SAMU judgment. That's in the SAMU. You will see that the challenge was brought directly, and my lady will see that from the litigation history at 11-12, because on that page the Constitutional Court deals with litigation history and deals with the procedural challenge from paragraph 15 and says those sections were directly relied upon. And then my lady will find at paragraph 66 of the judgment at 11-17 where the court deals with whether the challenge was well made. And it says at paragraph 66, Section 1953 of the Constitution directs that legislation must ensure the promotion of the values and principles listed in 1951. The Amendment Act aims to promote the values in Section 1951. This is because if one has regard to the preamble to the Amendment Act, Section 54, capital A, Section 56, capital A, Section 57, capital A, the amendment of other provisions of the Amendment Act, the purposes of the Amendment Act is succinctly summarized and enumerated in the High Court judgment. The amendment clearly seeks to promote a number of the values in Section 1951 of the Constitution. For example, the promotion and maintenance of high standard of professional ethics, the promotion of efficient, economic, and effective use of resources, and the cultivation of good human resource management and career development practices to maximize human potential. This, in terms of Section 73D of the Constitution, is enough to trigger the requirement that the bill should have been dealt with in accordance with the procedure set out in Section 76. As regards the claims, then he looks at the further. But what this tells you, my lady, is that there is an inquiry to be had to determine whether, in fact, the legislation is one that falls under 1953. And there are questions of fact that must be pleaded about the purposes of that legislation. It may be in the memorandum accompanying the bill, my lady, setting out what the legislation is intended to do. All of those matters must be canvassed, as well as the legal argument. Parliament was entitled to say, we reject their argument, this is the proper argument. They didn't do that. And so they are not, for instance, in the SAMU area. They are in the instance where they are asking, on fairness, my lady, to disregard the rights of Parliament and say they're entitled to raise the challenge in their heads of argument. After all the pleadings closed, all the annexes were attached, and there was no such challenge raised. We submit that's completely unfair, and it's not to stunt the DA with technical points, as the Constitutional Court has said, is to insist that it must be bound in fairness to its pleaded case. In fact, this judgment, my lady, can go back to them. They say that insistence is giving effect to the right in Section 34 of the Constitution, access to court, that the parties must be treated fairly. They must know what case they're called upon to meet and meet that case. But let's assume, against our argument, my lady says, I have a discretion, I'm going to look at this case. Is there a case of 195? And we deal with that at paragraph 23 of the note. My lady, the first thing that the court has to do in assessing that case is to look at what Section 195 says, because our learned friends have argued the point, but they have not invited the court to look at the structure of Section 195. We've quoted it conveniently at paragraph 17 of the note, my lady, page 11-6. It says, in the heading, basic values and principles governing public administration. So it's concerned with values and principles in public administration. And it says, 1, public administration must be governed by the democratic values and principles enshrined in the Constitution, including the following principles, and you have the list of 9 principles, and they have picked the last one, which is public administration must be broadly representative of the South African people, with employment and personnel management practices based on ability, objectivity, fairness, and the need to redress the imbalance of the past to achieve broad representation. And then 193 says, 2 is important. It says the above principles apply to administration in every sphere of government, organs of state, and public enterprises, not private enterprises. And then sub 3 says national legislation must ensure the promotion of the values and principles listed in subsection 1. So national legislation must ensure the promotion of the values and principles listed in subsection 1. They say the Amendment Act is legislation which is passed to ensure the promotion of the values and principles listed in sub 1, the last one, I. And therefore, it is legislation envisaged in section 1953 within the meaning of 763 of the Constitution, which says it is legislation envisaged in any of the following. So that's legislation contemplated in section 195.3, which deals with those principles in public administration. But what does the Amendment Act or the Employment Equity Act, is the Employment Equity Act aimed to deal with representativity in public administration? They have to say that for them to win the case on that point. But in deciding that issue, and I've referred to the Samu case, you have to go to the purposes of the Employment Equity Act and the provisions of Section 15 capital A that are under challenge. Firstly, when you go back to the Employment Equity Act as amended at 08-135, you'll find the purposes. The first place where you find the purpose is in the long title. It said is to provide for employment equity and to provide for matters incidental thereto. So it deals with employment equity in all workplaces, in the public and the private sectors. And it says also in the preamble, it is there to promote the constitutional right of equality and the exercise of true democracy, eliminate unfair discrimination in employment, ensure the implementation of employment equity to redress the effects of discrimination, achieve a diverse workforce broadly representative of our people, promote economic development and efficiency in the workforce, and give effect to the obligations of the Republic as a member of the ILO. And then you'll get Section 2 tells you the purposes also, because the court must look at those things. It says purpose of this act is to achieve equity in the workplace by promoting equal opportunity and fair treatment in employment through the elimination of unfair discrimination and implementing affirmative action measures to redress the disadvantages in employment experienced by designated groups in order to ensure the equitable representation in all occupational levels in the workplace. And then it tells you about interpretation at paragraph 3. Then 4 says, what does it apply to? It applies to all employees and employers, private and public. And then 5 talks about elimination of unfair discrimination. 6, prohibition of unfair discrimination, deals with medical testing, psychological testing, and similar assessments in the workplace. And then Section 15, capital A, the one that's in the bracket, not yet, is about sectoral, is about targets, numerical targets, setting numerical targets in all sectors of the economy. So the Employment Equity Act is far more broader than Section 1953 I that they rely on. Firstly, the Employment Equity Act is not limited to public administration. And secondly, the Employment Equity Act deals with not just representativity, it deals with measures taken to address unfair discrimination. It deals with medical testing, psychological testing. It actually deals with affirmative action measures. These are all broader than 1953. There may be some overlap with 1953, but it is not the legislation that's envisaged there. This is legislation envisaged in Section 9(2) of the Constitution. And if you go to the DA's case itself, even the submissions it made in that annexure to the replying affidavit, it focuses on Section 9(2) because this is an affirmative action measure. It is not what is required to be done in public administration. You'll see in SAMU that the court matched point by point the purpose of the act in that case with Section 195, the various principles and values, and said there it is achieving that, but you don't have that match here. So if my learned friend Mr. Nalani had stood up and said this legislation is justified because Section 195 requires it, 195(3)(I) requires it, my learned friend would have said all that 195 requires is you must have broad representation in public administration. You are not entitled to go fiddling with private employers and going in and in minutiae saying you must have so many of this and so many of that. It's fine if when you look at it you see the rainbow nation in public administration. But the employment equity goes much further than that. And that's why he has to locate the defense in Section 9(2) of the Constitution. And that's why even the attack by our learned friends focuses on Section 9(2). They say it is not a measure contemplated in 9(2) because it is an inflexible, a hard target which results in unfair discrimination and not the achievement of equality. That's what they argue. You haven't had them say it's not constitutional because you don't comply with 195(3). They would simply say that. They can't say that because this is not a measure, that's not legislation envisaged by 195(3) of the Constitution. It's a legislative measure that goes far broader, more ambitious than 195(3) of the Constitution. So with great respect, these matters would have been raised in the answering affidavit, and I would have obtained further guidance from my client on what to say in the answering affidavit on this challenge. But I was deprived that opportunity. My client was deprived that opportunity because the DA only thought of this challenge in its heads of argument. So it has made its bed, my lady. It's made it. It said, this is our case. In the founding, close it up in the reply. It must be allowed to lie on that bed. My lady mustn't be trying every other trick in the book to try to assist it. It is consistent with constitutional principle to say to the DA, sorry, you should have pleaded the case, and we submit that even if my lady were to disagree, there is simply no case based on 195(3). So the objective of having the entire act set aside simply on tagging and inviting the court not to have to enter the debate about the merits of the content challenge, my lady is stillborn. The tagging challenge has no merit, and we submit that part of the application should be dismissed. And we echo the submissions of our learned friend, Mr. Nalani, that the whole application should be dismissed because the DA doesn't make out a proper case for relief. My lady, those are our submissions, unless there are questions from the court. As the court pleases.
Thank you. Your reply?
Lady, if you decline to entertain the Section 195 points, and you do so on the consideration of the authorities, etc., we'd have to live with that. But we would, with respect, suggest it would be an injustice to have the court accept our learned friend's argument about prejudice and how they've been deprived of a proper opportunity to deal with the matter. They appear to forget, my lady, that there was an agreement, and in fact I think it was in terms of a directive of the court, as to the filing of heads of argument. My client complied with that direction, and we filed our heads of argument in which the point is taken, accepting for the moment, if you're with them, that it hasn't been pleaded. The point is taken expressly for the first time in our heads of argument. Those were filed in November last year, my lady. The respondents, including Parliament, only responded to those heads of argument in April this year, 6 months later. For them to seriously suggest that they were taken by surprise and could not respond, my lady, if they wished to, factually is simply not correct. There was more than adequate opportunity for Parliament to deal with the matter comprehensively, for my learned friend to take whatever instructions he wished, my lady, should he have so wished. And again, listening to his argument carefully, he says, I would have sought guidance from our client, but he doesn't indicate what might have been forthcoming. What we do know is, as we've referred to already, in the affidavit they deal in an admirably succinct manner with the tagging challenge, and they say what they have to say. There is absolutely no reason to suggest that if we merely tagged on an express reference to 195, read with 76, that would have been the spur for an enormously different factual investigation. Why would it have been? It's a far more focused legal point than the functionality point. But they contented themselves with what they put up on functionality, and there is absolutely no reason to believe that anything different would have been said, milady, had we expressly referenced 195. I point out that in Beta Star, I don't have the reference, I don't think the parties have referred to Beta Star, but the court would be well aware of it. In Beta Star, and I was responsible for this, running the case without pleading specifically Podge's provisions that we ultimately sought to rely upon, the court said, and this court would be familiar with that principle, you don't need to explicitly reference provisions of a statute that you rely upon, provided that the facts suffice to bring you within the compass of the statute. So you do not need to trot out in a formulaic manner, I rely on section X of statute Y, if provided always, milady, that the facts that you do allege come within the compass of the statute. My learned friend referred to the authority, sorry, where is it? This case. Oh, sorry. The Lagoon Bay judgment, I believe, milady, in support of his arguments, and it's Mashlantla AJ's. Was this? Actually, then was this? Yes, this is Lagoon Bay, Constitutional Court. Constitutional Court judgment in Lagoon Bay, milady, and the distinction there, I just want to draw to the court's attention. The court would probably have realised that by now. As the heading before para 35 makes clear, there was an entire failure, milady, in that case, to challenge the unconstitutionality of provisions of LUPO whatsoever. So that was the essential reason why the court says you cannot raise such a matter. There was zero constitutional challenge. Here there was a constitutional challenge from the outset, milady. And with respect, that renders the Lagoon Bay judgment entirely distinguishable. I am going to deal, as I think is apparent now, with the tagging issues that my learned friend Mr. Manache raises first, milady, and then deal with the substantive challenge in reply. With regard to, and I'm effectively going to do it in the order in which it was presented, milady. So, if we understood our learned friends correctly, when they refer, milady, in para 9 of the notes to the judgment of Rogers J, as he then was, in DA versus President of the RSA, milady, and Rogers J's dealing with Tongwane, I didn't understand, and if that was the thrust of the submission, then we respectfully disagree with it. Tongwane, milady, the test laid in on Tongwane that we referred to and I took you to this morning extensively, which you find, milady, as I submitted to the court, the Russian and Tongwane is para 58, and it's adumbrated upon in 59 and 60, milady. We stand by that as being the correct test. with the greatest respect to Rogers J, lady, even being Rogers J, I don't think he would have purported to be adding a gloss to Tongwani, which would then in some way change what the Constitutional Court in Tongwani was saying, and with respect, he wouldn't permissibly be able to do so. So we stand by the tests. The addition of the words actually regulate, which our learned friends wish to emphasize, we submit properly construed doesn't purport and should not be understood as a narrowing down or setting a higher bar, my lady, than what was said in Tongwani. That would be impermissible. Tongwani requires, in simple terms, my lady, as I said to you, test is to be found in para 58. The simple question is whether the provisions of the bill in substantial measure fall within a functional area listed in Schedule 4. That is the test. The adumbration of that, my lady, which I also referred you to, is what you find at the end of para 60. The more a bill affects the interests, concerns and capacities of the provinces, the more say the provinces should have on its content. That is not a formulation of a test. It is an explanation of how the test finds application, my lady. The test is para 58. And with respect, nothing that Rogers says could or should change that. With regard to, but to the extent our learned friends then make submissions based on, well, quite clearly, these provisions in the Amendment Act do not purport, nor do they actually regulate trade, nor do they actually regulate any of the other matters that we've identified in para 45. We disagree. We've made our argument. They clearly regulate matters that fall within those areas. We've listed how those areas are coterminous. We do not have to go further and establish that they actually regulate those areas. But if we had to, my lady, then we rely upon and refer to the simple fact. Now, learned friend Tuku, you'll recall, through it and he says, well, how does rearranging or imposing targets in respect to demographics, how can that possibly be considered and a bill or the provisions be regulating trade? Now, with respect, we say, firstly, that's the wrong test, but even if that is the correct test, it regulates trade incredibly intrusively, my lady, and impermissibly, unless it's tagged correctly as a 76 bill, because it imposes an obligation on employers within a particular province, my lady, in fact all the provinces, to rearrange their affairs. And my learned friend says, well, you're supposed to all be competent in any event, so it shouldn't make a difference. But with respect, the potential to not only intrude, but to disrupt, my lady, the operations of businesses within a province, thereby directly affecting the province in terms of revenue, in terms of a range of things. And I'm not talking about a knock-on effect. We're not getting locked into a semantic dance. I'm not getting locked into a semantic dance with Mr. Manesha, as attractive as that might be, my lady, about this, because that's not the issue. The issue is, does it fall within a functional area? Finish and cloth. And we say it does, and we say it substantially affects the interests of provinces for that reason. So yes, it would regulate trade, it would regulate promotion of industry in the broad sense in which the Constitutional Court which case? Trade. In Liquor Bill, the Constitutional Court gave trade, you'll call, and promotion of industry a broad interpretation. There's no reason to depart from that in your analysis. So we say, yes, it does. Whether you take their actually regulate or our test, it has the same consequence. It does regulate it. It does regulate it. It does affect it. Then my learned friend's argument proceeded in relation to the tagging issue. He says, well, even if we reach 195, we haven't demonstrated that this is legislation contemplated in 195. Now, your ladyship indicated I should deal with that in reply, so I'm going to deal with it.
Yeah.
Now, with respect, our learned friend's argument goes, as we understand it, like this. He says, well, firstly, we are to identify which provision in 76 is of application. Is it 1953 or 1954, and which of the subsections in 76.3 of application? Well, we've clearly, in our heads of argument, referred, milady, to 76.3D, read with 195.3. The provisions of 195.4 have never been applicable in this matter. So those are the ones we identify. 76.3D, read with 195.3. Now, if one then goes to 195, milady, 195.3, you'll recall 195.1 lists the principles which are applicable to the public service, to the public administration, and one of them is the requirement that the public administration be broadly representative of the South African people with employment and personnel management practices based on ability, objectivity, fairness, and the need to redress the imbalances of the past to achieve broad representation. Then sub 3, milady, national legislation must ensure the promotion of the values and principles listed in subsection 1. And as I say, that's the one we rely on. Our learned friend says, well, there's no indication this is that legislation. And then he also queries whether the Amendment Act is intended at all to address the public administration, if I understood the argument correctly. We submit that there's no force in either one of those arguments. Milady, the principles, if one just on a cursory glance at the principles in 1951 would see that they deal with a range of matter, milady, which is unlikely, if not impossible, that any one single piece of legislation would deal with. So that's our first response. If you simply look at it, it deals in A, milady, with a high standard of professional ethics. B is efficient economic and effective use of resources. C is development orientated, the public administration. D is services must be provided impartially, fairly, equitably, and without bias. E is people's needs must be responded to, and the public must be encouraged to participate in policy making. F, public administration must be accountable, and so it goes, milady. H deals with good human resource management and career development practices to maximize human potential, and the need for this to be cultivated. And then I deals with what I've read to you already. It's quite clear that these deal with a range of issues, milady, and it's highly unlikely, if not impossible, that one piece of legislation would deal with any one of them. The obvious way to read, milady, sub 3 is that there must be national legislation that ensures the promotion of all of those values and principles. That's point number 1. Point number 2, milady, our learned friend's argument proceeded on the basis, as we understood it, that, well, given that this does not, that 195 only applies to the public service, the public administration, given that the Employment Equity Act clearly is broader, its range, its reach is broader, there's a dissonance between the two. Now, we have no quibble with the fact that the Employment Equity Act is broader than the public administration. We made that point at the outset. The definition of designated employer, milady, includes, as you know, every municipality, every organ of state, except for those few exclusions, any employer with more than 50 employees, or with less than 50 employees, but with a greater than prescribed turnover. They're all covered. So clearly, it's broader than the public administration. But what has that got to do with the tagging question? The tagging question. We've already made the point in our main argument that tagging is not a question of the purpose of the legislation. So I'm not going to repeat that argument, but here we're dealing with the tagging argument. And the only question is are the requirements of 76.3 met? And the requirements of 76.3 are met. 76.3D, milady, are met if this legislation is legislation that ensures the promotion of the values in I, which we've identified. And to reiterate, public administration to be broadly representative of the South African people, as I've took you to right at the outset of my address, one of the express provisions in the preamble to this act, milady, is to achieve a diverse workforce broadly representative of our people. A verbatim take from 195, 195I, milady, 195 And then, forgetting about semantics, in its substance, it clearly, milady, is legislation. If you cannot call this act, the Employment Equity Act, a piece of legislation which is inter alia, milady, attempting to ensure the promotion of a public administration that is broadly representative of the South African people, and addressing the need or addressing the need to redress the imbalances of the past in such administration. If you can't call this such a piece of legislation, then we are somewhat bemused as to how you would characterize it. The fact that it deals with more than that doesn't denude or denigrate from the fact that it does unequivocally deal with that, and that the public administration is, as we all know, the biggest single employer in the country. So a significant part of the reach of this act, milady, not an inconsequential or insubstantial, a significant part of the reach of this act is precisely what 195 deals with. So we persist with respect with our reliance on the tagging as being incorrect, milady. We submit that this should have been tagged as a Section 76 bill, not a Section 75 bill, and that the failure to do so is fatal. Our learned friend seeks to derive some assistance from the fact he says, well, look at what a profound consequence that would have to render the entire Amendment Act invalid, unconstitutional. Well, it doesn't depend on the 195 argument to have that consequence. That's the natural consequence of the argument that we have pleaded as to tagging. So on either basis, it leads to that conclusion, milady. Another argument my learned friend made is he says, well, we're not going to be prejudiced because we've had a full opportunity to argue the matter, and we've got all these other grounds of attack. But with respect, milady, that fails to understand and apply the absolute imperative that exists on this court in terms of 172(1)(a), where a court, if you find that legislation, milady, or an act is unconstitutional, you are bound to declare it as such. And we submit that that is your principal obligation, to uphold the law, milady. If you are satisfied on a conspectus of the facts that are properly before you, the submissions you've heard, that this legislation does fall foul of the requirement that it be tagged in terms of Section 76, that is a significant, milady, breach by Parliament of its obligations under the Constitution. And we submit you would be bound to so declare it and to act in terms thereof. So we persist with respect with our tagging argument on both bases, milady, and we say this would be an appropriate case. If you do find that we've erred, I found one thing, milady, with regard to the express pleading of the Section 195 issue, we submit there's no prejudice. By the same token, apropos my learned friend's argument that I've just summarised, they've had a full opportunity to argue the matter. They've had 6 months to cogitate upon our raising the matter. It's no surprise to them, milady. And our learned friend, as to be expected, being experienced counsel and good counsel, worked up a very well presented and developed argument this afternoon on 195 as well. So they've suffered no prejudice with respect. With regard to the substantive challenge, milady, there are two aspects really that I want to address. I'm not going to repeat my arguments of earlier. The first, milady, relates to Our learned friend's argument that, and his reference to Van Rooyen, I believe, Constitutional Court case where he quoted Chaskelson P, as he then was, saying that, well, any piece of legislation or the Constitution can be abused, and if it is, the remedy lies in challenging the abuse and not the legislation as being unconstitutional. Yes, there is that dictum, but there are also other dictum, milady, and we'd like to refer to other dictum which we submit also to the Constitutional Court, which are more appropriate and applicable, milady. And in fact, it is Dawood, the Dawood judgment, which we've referred to, both parties are referred to in a different context, milady. And I want to refer you to para 44. Sorry, 46. In para 46, the court refers to the fact, milady, I don't know whether you have the judgment handy, Dawood?
It's 12,444.
It's 12,444, milady.
I'm trying to get there. Is it on item 12?
I'm sorry?
Is it item 12?
It's case lines 12,444. I don't know it's item 12. I don't.
It's 12,444.
It's a page, the case lines.
Reference.
You have it, milady? 12.
Case lines reference.
Excuse me?
Is it a case lines reference?
Yes, 12/444, milady.
Okay.
You have it?
Yes, you said paragraph?
Could I take the court to para 46, milady?
Okay.
Where the court says, the Constitution makes it plain that all government officials, when exercising their powers, are bound by the provisions of the Constitution. And then the court goes on. There is, however, a difference between requiring a court or tribunal in exercising a discretion to interpret legislation in a manner that is consistent with the Constitution and conferring a broad discretion upon an official who may be quite untrained in law and constitutional interpretation, and expecting that official, in the absence of direct guidance, to exercise the discretion in a manner consistent with the provisions of the Bill of Rights. Officials are often extremely busy and have to respond quickly and efficiently to many requests or applications. The nature of their work does not permit considered reflection on the scope of constitutional rights or the circumstances in which a limitation of such rights is justifiable. We submit with respect that the same considerations apply, perhaps more so, milady, to a busy minister of state as opposed to a lower level official. And then it is true that as employees of the state, they bear a constitutional obligation to seek to promote the Bill of Rights as well, but it is important to interpret that obligation within the context of the role that administrative officials play in the framework of government, which is different from that played by judicial officers. It is an important principle of the rule of law, milady, which I've referred to as being the principal obligation and the principal obligation on you to apply the rule of law, that rules be stated in a clear and accessible manner. It is because of this principle that Section 36 requires a limitation of rights may be justifiable only if they are authorized by law of general application. Moreover, if broad discretionary powers contain no express constraints, those who are affected, and this is a second distinct reason, those who are affected, not only the decision maker, but the affected individuals, do not know how to arrange their affairs to bring themselves within the ambit of whatever the dispensation is. And that is what is reflected there. Will not know what is relevant to the exercise of those powers or in what circumstances they are entitled to seek relief from an adverse decision. So that, those dicta from Dawood are powerful, we submit, foils, and they refute our learned friend. Sure, in a perfect world, every official, including ministers, would be diligent, they would never breach their obligations, etc., and they would act always within the confines of the law. We all wish we lived in such a state, milady, we don't. And that is why the courts say that a blank check book is a bad thing. And that's our argument. There's one final factual argument that I want to advance. Our learned friend for the Minister argued, my lady, he was referred to the solidarity judgment and to the spat in that judgment between Zondo J and Nugent AJ as to whether or not quotas, whether or not the system that was at issue in solidarity amounted to a quota system. And the disagreement turned, my lady, on whether or not it was such as to be quotas in the sense that they were inflexible and rigid. And I just want to... Yes, I did refer you in my earlier address, my lady, to para 51 of this judgment, where the court makes the point that you'll recall, to show that the numerical targets are quotas, they need to show that they were rigid. That's para 51. Now, following from that, there's this debate as to on the facts of this case. Now, once again, I reiterate, we're not dealing with a fact-based case, my lady. We're dealing with a case in abstract. This is an abstract challenge. But apropos the issue in this case, and this deals with the question of flexibility, which was why our learned friends refer to this. The argument, as we understand it, ran, well, the equity plan here at issue was found to be flexible and hence sufficiently flexible as to not to constitute either a quota, and remember, it doesn't need to be a quota, it can simply be inflexible and providing an insuperable barrier. That is also not permitted. So that's the argument. It's sufficiently flexible to not be a quota. Now, this is a pre-amendment case, my lady, and the equity plan conceived and drawn up pre-amendments. And it's in that regard that Zondo J, as he then was, deals with this. And he says, no, Nugent AJ is wrong. In 56, he says, in his separate judgment, second judgment, Nugent AJ disagrees with my conclusion that the numerical targets of the 2010 EE plan, Employment Equity Plan, were not quotas, and with my reliance on the provisions relating to deviations in this regard. He expresses the view that the deviations were not part of the 2010 plan, but were separate. In effect, he says that they may not be taken into account in deciding whether the numerical targets were rigid and therefore constituted quotas. I disagree. And then what follows is an entirely irrelevant consideration for our purposes of why this particular plan did or did not constitute quotas. But the essential point is whether or not they form part of the plan or not. Because Zondo's approach was that if they form part of the plan, the ability to deviate, then they, by definition, because they're part of the plan, you can deviate within the plan, they're not rigid and they wouldn't constitute a quota. Nugent, AJ, viewed it as not being part of the plan, the ability to deviate being outside the plan. And he said because it's outside the plan, it doesn't save the plan from being too rigid, because the deviation could only be dealt with outside the plan, and the plan itself remained rigid. But that was the issue in this case. But with respect, and obviously that's not the issue in this case. Our case, my lady, is, and herein lies the rub, which the reference to this case brings into stark relief. Before, we could have had this debate, and we could have looked at the plan to see, is it rigid or is it not? And does it cross the line or not? Now, we don't have the luxury of doing that anymore. The minister has decided that regardless of what your plan says, and you'll recall my learned friend argued, there's still all these provisions. You still have to have a plan. You still can develop it. Yes, we accept that. We are still within the realm of the plan. We are still within the realm of consultation. But all of that, my lady, can be undone with a stroke of a pen, and has been undone, because the minister can come from above and say, I don't care what your consultation led to. I don't care what your consultation disclosed. I don't care what your employees want. I don't care what the unions want whom you consulted with. I'm telling you that not only you, but everyone in the country, forget about the province, everyone in the country whether you're Pick and Pay, whether you're Checkers, whether you are Mug and Bean, it doesn't matter. You shall, if you operate in the food industry, the food sector, you will, at your top management level, employ X number of people, and you will reach these targets after 5 years. Therein lies the inflexibility. And if you cannot do that, Mug and Bean or Checkers, get rid of someone. That is the inflexibility, that's the insuperable barrier, that is the indignity, and that is why this is offensive. We stand by our submissions, milady. We ask that the application be granted in terms of prayers 1 and 2 of the notice of motion, and we persist with our submissions in respect of costs. As court business.
All right, thank you for your comprehensive arguments that you've presented and the heads that you've prepared. Also for the authorities that you've uploaded, and the 1 or 2 authorities that you've indicated you'll still upload, please go ahead and do so. The court is going to reserve its judgment and will inform the parties once the judgment is ready. Thank you. The court will adjourn then.